Hello. Just checking if you can hear me. Okay, perfect.
Dr. Cleveland, if you would do roll call, please.
Yes, ma'am. Dr. Owens, Dr. Lippincott, Dr. Joyner, Dr. Kennard,
Here.
Dr. Gersh, Dr. Givens, Dr. Dotson, Dr. Loper, Dr. Roth,
Here.
Ms. Games. Madam President, you have a quorum.
Thank you, Dr. Cleveland. Board members, for your information, we are shifting from the binder today to Surface Pro. So the document should be included on your Surface Pro today. There are a couple of items behind tabs 19, 20, and 21, though, that have been added to the binder. All right, so. But I know for sure that the most updated information should be loaded on the Surface Pro. There we go. Let's see. I got it. Thank you. Yep. All right. So in moving on with the agenda, the first item for this morning is a show cause hearing in the case of Dr. Nathaniel Brown, license number 10093, reinstatement from Cleveland, Mississippi.
Madam President, Madam Hearing Officer, I'd like to go through some housekeeping matters before we begin. I just handed Dr. Brown a copy of the documents that I intend to use as exhibits. And I would like to go through list through them and explain what they are and see if Dr. Brown has any objections. Is that permissible? All right. And it's my understanding these documents are already available on the Surface Pro. And I'm referring to the Bates numbers in the bottom right-hand corners of the page that begin with MSBML. Page 1 through 2 are the current summons. Pages 3 through 6 are an affidavit of Jonathan Dalton dated 6th of December 2024. Pages 7 and 8 are an emails between Mr. Dalton and Dr. Brown confirming receipt and acceptance of service. Page 9 is a letter related to the same thing. Pages 10 through 16 are Dr. Brown's current petition for permanent reinstatement. Pages 17 and 18 are the denial letter where the executive director denied the application. And so first I'd like to stop there to see if Dr. Brown has any objection to those current exhibits.
I do not.
Okay. Going on, we're going back in history a little bit. Pages 19 and 20 are a summons from the year 2018. Pages 21 through 23 are an affidavit of Jonathan Dalton dated 14 December 2017. And with some proof of service forms that go through page 25. Page 26 is a printout from the Federal Bureau of Prisons. Um, 27 and 28. 27 through 29 are communications with Dr. Brown and a declaration of authenticity from the 2018 proceedings. Included in those documents, there's a number of things. Pages 30 through 33 are Dr. Brown's original application for licensure. Page 34 through 44 are a copy of the indictment of Dr. Brown from 2016 and some proof of mailing. Pages 45 through 47, excuse me, make that 48. That's another copy of Mr. Dalton's 2018 affidavit, and then a duplicate of the prison document, Bureau of Prisons. Page 51 is where 51 through 53 are a plea agreement that was entered back in 2017. And the certificate for the next starts on 50. I'm sorry, that's all part of the indictment. And I would describe pages 54 through 61 as being documents related to Dr. Brown's guilty plea, including restitution, etc. Pages 62 through 65 are a determination and order of this board, February 1st, 2018, revoking Dr. Brown's license. Beginning on page 66, and I think there's two copies in here. I think from 66 to, actually, I know, let's apologize for saying I believe, from 66 to 85 is a CPAP clinical assessment that Dr. Brown undertook over 3 years ago on January 12th through 13th of 2022. Item 86 is a letter from 2018 from the OIG, Office of Inspector General of HHS, informing Dr. Brown that he was placed on the exclusion list for federal programs for a minimum period of 20 years. The next few pages, 88 and 89, 88, 89, 90, and 91 are additional communications from the OIG to Dr. Brown about his exclusion. Page 92 is a document that was printed on October 14th, 2024 from the Office of Inspector General website, confirming that Dr. Brown is still on the exclusion list. Then pages 93 through 112 is a duplicate of the CPAP assessment. And page 113 is a document that was printed on January 7th, 2025, again confirming that Dr. Brown remains on the OIG exclusion list. That's simply an updated document that was printed last week. Those are the exhibits I plan to introduce, and so I'd ask if Dr. Brown has any objections.
Any objection?
I do not.
Okay, so admitted at this time. Also, if we could get Dr. Brown sworn in, I have a couple of questions to ask him prior to the start of these proceedings.
Someplace where or from testimony you're not giving this concentration or something
Okay. Dr. Brown, my name is Alexis Morris. I will serve as the hearing officer in this matter today. It is my role to rule on any objections to any evidence or testimony presented today and to ensure the orderliness of the proceedings. Are you represented by an attorney? Okay. Do you understand that you have the right to an attorney?
I do.
Okay. You also understand that you have the right to have any witnesses testify on your behalf today?
Yes.
Okay. You further understand that you have the right to have subpoenas issued on your behalf about this matter as well?
Yes.
Okay. Notwithstanding the same, you wish to proceed today without counsel representation?
That's correct.
Okay. Thank you.
Now pursue my opening statement.
Yes, please.
Dr. Brown was part of one of the biggest cases of healthcare fraud in Mississippi history. His role was to fraudulently certify patients as eligible for hospice care when in fact he knew those patients were not in fact qualified for hospice care. This was a scheme that was carried out with persons owning hospice facilities and running hospice facilities in which all of the defendants received very substantial amounts of money. This resulted in Dr. Brown's indictment on, I believe, 6 charges of healthcare fraud. He was allowed to plead guilty to 1 count. That's shown in the plea agreement. In that plea agreement, which we can go to, I'll go through in a little bit of detail with Dr. Brown on the stand. He confesses, he admits his fault, he admits his guilt, admits that the government's allegations about healthcare fraud and conspiracy are true. He agrees to pay approximately $1.9 million in restitution to the federal government. And there are some other terms also, but those are the primary ones. The court accepted Dr. Brown's guilty plea to healthcare fraud. Dr. Brown was sentenced to 39 months in federal prison. Dr. Brown was also then sentenced to 3 years of supervised release or parole. It is my understanding that Dr. Brown's parole ended at some point last summer in 2023 or last spring, March
2nd.
March 2nd of 2023. So he is no longer on parole. Dr. Brown's convictions or conviction constitutes a felony of moral turpitude. It is fraud. It is not merely fraud. It's not merely moral turpitude. Was a crime that not related to his practice of medicine. It arose out of his practice of medicine. So it cannot be more closely intertwined with Dr. Brown's professional actions. Dr. Brown submitted a complete new application for reinstatement. That's in the materials on 10 through 16. And the executive director, after considering the application and everything submitted in support of it, issued a denial letter. And he denied Dr. Brown's reapplication because of the healthcare fraud conviction, because of the conviction of moral turpitude. The board also caused a show cause order to issue after Dr. Brown informed us that he wished to appeal in addition to a crime of moral turpitude. The show cause order also specifies that Dr. Brown lacks the good moral character, which is a statutory requirement for anyone seeking a license in the state of Mississippi. Also, unprofessional conduct. Excuse me. I can't read my own notes. The fourth being receiving final sanctions from the United States government, HHS, OIG. And the show cause order lists the statutory subsections for each of those that shows that they are in fact individually and collectively grounds for denying an application. Dr. Brown is going to have the opportunity to speak to the board and convince the board that despite his past actions, despite his healthcare fraud conviction, despite everything that went along with that, that he is now fit to practice medicine, that he is trustworthy, and that he is worthy of this board giving him a license to once again go out and practice medicine. And in that regard, I will attempt to show through the evidence how important a doctor's word is. I know you are all aware, not simply a doctor's word, the doctor's signature, which constitutes his word, a doctor's signature on a prescription, a doctor's signature on an order, a doctor's signature on a medical record, on a discharge summary. If other healthcare providers cannot rely on a physician's word, on his signature, then the system cannot work. Dr. Brown, I have sympathy for Dr. Brown. We all have sympathy for someone who's had created such a terrible situation in their life. However, the facts are that he pled guilty to healthcare fraud because he was in fact guilty of healthcare fraud, and that he made a lot of money through the scheme of healthcare fraud. And that's what the evidence will show. And those are the reasons why I will be asking the board to deny Dr. Brown's application.
At this time, Dr. Brown, do you have an opening statement or any information you would like to present to the board?
Good morning, and thank you all for this opportunity. I'm here today to tell you all that I made some serious mistakes in the past while working with hospice. I was naive, greedy, and selfish. I paid dearly for these mistakes. I learned a lot, most importantly. I'm now opening a new chapter in my life and moving forward to bigger and better things. I have applied for a federal pardon and pray that it may be forthcoming very soon. Thank you.
I call Dr. Brown as an adverse witness.
Dr. Brown, will you please have a seat?
Thank you, sir.
Good morning, Dr. Brown.
Good morning.
As I introduce myself, I'm Paul Barnes, the board attorney. I'll be asking you questions today, but if you could direct your answers to the board, and I'll try to remind you to do that because, of course, they are the judge and jury. They decide whether or not your application will be granted or denied. So why don't we start? Just tell the board how you got involved in the healthcare fraud and what your role was?
Well, I was a medical director, one of the medical directors for hospice. I didn't know, because of my naiveness, that the hospice directors were committing healthcare fraud. I was simply a pawn in their scheme. And I had wanted to fight these allegations tooth and nail, but because of the advice of my attorney, he said to me, you don't have enough money or enough attorneys to fight this. So your best bet is to plead guilty, take your sentence, whatever, and then move forward with your life.
So I believe I just heard you say that you were naive and unaware that the owner of the hospice was committing healthcare fraud. Is that right?
That is correct.
Did you give a copy of the exhibits to the witness? Dr. Brown, these are the exhibits that I just listed, and I want to ask you some questions about some of them.
Sure.
Do you see the identification numbers I put in the bottom right-hand corner?
I do.
Okay. I would like you to turn to page 51, please.
Major glasses.
At this moment, probably not. This
You
seems to
want me
be
to bring you your glasses?
okay. I think it is a good idea. Thank you. Appreciate that.
I know I would not be able to
Thank
read
you.
this
It is,
without.
it's helpful.
Okay. Now, page 51, have you seen this document before?
I have.
Okay. This is described as a plea agreement. Is this in fact the plea agreement that you entered into with the U.S. Attorney's Office?
It is.
Paragraph 1. Guilty plea. The defendant agrees to plead guilty under oath to count one of an indictment, which charges that the defendant, Nathaniel Brown, did knowingly and willfully conspire and agree with persons known and unknown to the grand jury to execute a scheme and artifice affecting interstate commerce to defraud a healthcare program, that is, Medicare and Medicaid, and to obtain money and property owned by and under the custody and control of Medicare and Medicaid by means of false and fraudulent pretenses, representations, and promises in connection with the delivery of and payment for healthcare benefits, items, and services. And then it goes on to list the statutory sections. Did I read that correctly?
You did.
Okay. If you would, turn over to page 53. The first complete sentence on page 53 states, the defendant is pleading guilty because defendant is in fact guilty. I read that correctly, did I not? At the top of the page, sir.
On top page 3.
53. 53.
Yes, that's right.
Then there's a date, 21st day of November 2016. There's a signature reporting to be from Felicia Adams, the U.S. Attorney. Then there's a statement agreed and consented to. Is that your signature underneath there?
That's correct.
And then it says approved. There's a signature for Terrace Harris, listed as attorney for defendant. So at that time, you were represented by counsel and had his advice as to whether or not to enter into this plea agreement.
That's correct.
And the court accepted your guilty plea, did it not?
Yes.
And as I described in my opening statement, you were sentenced to 32 months and 39 months imprisonment, correct?
That's correct.
You were also sentenced to 3 years of supervised release, which is also known as parole.
Correct.
You completed your prison term. You completed your parole.
Correct.
How much did you have to pay in restitution to the state? I'm sorry, to the federal government?
I believe the summarization was that I was liable for approximately 500,000. When they added on the other people who were involved, it's called joint and several. That made it 1.9 million.
Right. And if you look on page 60, there at the top, it lists the amount of restitution as $1,941,254, which is, as you said, 1.9 million. And then on page 61, down on toward the bottom under joint and several, it says that you're jointly and severally liable with Sandra Livingston for 361,000 and some odd dollars, that you're jointly and severally liable with Laura Lynn Thompson for $271,000, jointly and severally liable with both Livingston and Thompson for $736,688.02. And says the defendant is individually liable for $570,839.49. Right? Those numbers accurate?
Yes, they are.
And you mentioned joint and several. That's where the judge held that you and your co-defendants each, both jointly and severally, owed that money and were required to pay it back. Correct?
Correct.
And that's what you mentioned when you said that adds up to the $1.9 million.
Correct.
Did you pay the $1.9 million?
No, I paid, been paying incrementally, but I've not paid $1.9 million.
How much have you paid? How much, well, let me ask you this. How do you make payments on this restitution amount?
I make monthly payments, and the district court attorney has been taking money out of my Social Security for approximately 2+ years.
And how much is that? How much credit for payment are you given each month?
I think the judge ordered me to pay $950 per month.
Okay.
And that's how much is currently being paid.
So when did you start paying?
After my release from prison, that was in February of 2020.
Okay. Did you make payments while you were on probation?
I did.
Okay. So it started in 2020.
No, it started in 2020 when I was released from prison.
Right. I know the payment started in 2020. Correct.
Well, actually, that's not correct.
Okay.
I was making payments when I was incarcerated as well. And then I started making payments in 2020.
Can you give me a rough figure for how much of this money you've paid back?
I can guess, because I don't know. At $950 per month for 3-4 years, that's probably close to 100,000.
Okay.
And keep in mind, this is joining several, so the other people weren't liable for the joining several part.
All right, I'm not a math whiz, but I'm checking $950 times 12 months. Let's round it up to 1,000. That's $12,000 a year, and you've been paying for 4 years. That's $45,600.
Okay, yes, yes, your math is better than mine.
Roughly. But so you still have a long way to go before you satisfy even the 500 and some odd $1,000 that you individually owe.
That's correct.
And a very long distance before you reach before the one. Let me strike that. With joint and several liability, we'll make sure your understanding and mine are the same. With joint and several liability, the government is going to go after everyone they can and try to get their 1.9 million. And once they get their 1.9 million, they're going to stop, whether they get it from you or your co-defendants or any combination of it. And then as far as whether or not you have any right against your co-defendants, that's between you and them, not between you and the government. Correct?
I believe you're right.
Okay. Let's talk about what your practice might look like if this board was to reinstate your revoked license. And first, and I don't want to have to dig through these documents unless we need to, you did not appear when you were charged with unprofessional conduct and charges before the medical board attempting to take your license, did you?
No, I was incarcerated in Montgomery, Alabama, and it was impossible for me to leave that prison situation and come to an appearance before the board.
Right. Were you given notice that the hearing was going forward and then an opportunity to contact the board about it?
I'm pretty sure I was given notice, but I also was told by my counselor that I could not go.
Okay. So the board held a hearing with you after giving you notice without you being present, correct?
Correct.
Present. Did I say president? I apologize. All right. So the board in its order found you guilty of having been convicted of a felony involving moral turpitude and unprofessional conduct. Is that correct?
That's correct.
Did you appeal that order to
I
the
didn't.
courts?
I did not.
So that order has been on the books since 2018, correct?
Correct.
Now in January 12th and 13th, you went to CPAP for what appears to be a clinical assessment. Am I describing that
Yes,
correctly?
that's correct.
Okay. Why'd you do that?
It was required by the medical board in my application for reinstatement, for possible reinstatement of my medical license.
Mhm.
I think there's a rule that says if you've not practiced for 3+ years, a doctor must take an organized learning like CPAP.
And in this CPAP assessment, there's a lot of different areas that CPAP tested you on,
That's correct.
right? I note that one problem that the CPAP personnel saw more than once was that you were late for your appointments, late for your structured interviews for this process, for which you were trying to get your license back. Is that correct?
Well, the problem was we have terrible broadband in the Mississippi Delta, so it was impossible for me to get on the on internet on those instances.
Did CPAP not try to assist you with those technical problems so that you could complete this process?
They did not.
They did not.
They did not.
Now, in this assessment, as far as the substance of it, in some areas, CPAP states that they found your performance to be adequate, and in other cases, they stated that they found your performance to be inadequate. Correct?
Well, I think you need to read what they said and not try to paraphrase it.
All right, let's look on page 74. This is the best example I could find as I was reviewing last night. Do you have that page?
I do.
Okay. Top, clinical judgment and reasoning. Dr. Brown's clinical judgment and reasoning, as demonstrated during this assessment, ranged from acceptable to inadequate.
That's true.
Correct? The next page, CPAP lists educational needs for clinical judgment and reasoning. So they're offering these areas as areas of weaknesses for which you need additional training or education to make your performance adequate, correct?
Correct.
Right after clinical judgment and reasoning, on page 75, there's a section on patient care documentation. The disclaimer on page 75 says that the evaluation was based solely on notes written at CPAP because charts from his former practice were not available. For this reason, no assessment of his ability to manage and organize a complete chart can be made. I read that correctly, did I not?
Yes.
The next page, 76, there states that overall, Dr. Brown's SP documentation was mostly adequate with room for improvement. He demonstrated he understood most of the components of acceptable single encounter patient documentation. And then there's a list of educational needs for documentation. So even though the assessment states that your documentation was mostly adequate, they still found weaknesses that they believe needed to be improved, correct?
That's correct.
All right. Practice-based learning. They again would say they list a couple of topics of improvement and educational needs for practice-based learning. On page 77, they concluded that you demonstrated mostly adequate communication skills with areas for improvement. And then under physician-patient communication skills, they list a series of areas in which you need improvement, correct?
Correct.
If you turn to page 78, the bottom, number 2, observations of behavior and additional considerations. Dr. Brown was pleasant and cooperative towards CPEP staff and clinical consultants and conducted himself in a professional manner throughout the assessment. He submitted all the required documentation in a timely manner. Dr. Brown appeared to struggle with punctuality and the computer skills necessary to participate in a video conference remote format process. He did not appear to anticipate the need to familiarize himself with his computer, even after CPEP staff reviewed the process for logging into the clinical interviews and instructed him to log in a few minutes early to each clinical interview during the CPEP orientation. He was late to 2 of the structured clinical interviews, 15 minutes late to one and 45 minutes late to another. For the second, he spent most of the time he missed attempting to get logged on and having technical difficulties. These delays decreased the amount of material covered during the interviews. I know you said earlier that your problems were due to technical problems with your internet connection. Did you not make any effort to go to a location where you could get a better internet connection? This assessment being so important to your career, did you not find it important enough to go where you could get a good internet connection and have a video conference with CPAP?
Well, the problem is we have terrible broadband in the Mississippi Delta. And I think this was during COVID also. So it was very difficult to deal with both of those two problems. So you say I could have gone elsewhere, and I don't know where I could have gone, number one. And then number two, the unfortunately, our broadband and our internet in the Mississippi Delta is atrocious.
Do you know whether there are physical locations in the Delta, whether libraries or hospitals or businesses or law offices where in fact they do have good internet connections?
Well, some of these days I was at Delta Health Center, which is a medical facility. And normally we do have good internet connections, but unfortunately, Well, I should say that's not true. Sometimes we don't have good internet, and that's simply a problem with the entire system in the Mississippi Delta.
I'd like you to look at page 86, please. Now I'm getting near the end of asking you to leaf through these documents. '86 is a document dated May 31st, 2018 from the Department of Health and Human Services Office of Inspector General. Is that correct?
Correct.
States, this is to notify you that you are being excluded from participation in any capacity in the Medicare, Medicaid, and all federal health care programs as defined in section 1128 BF, sorry if I'm speaking too fast, of the Social Security Act for a minimum period of 20 years. Minimum period of 20 years, correct?
Correct.
You are still on the exclusion list, correct?
Correct.
At the bottom of page 86, that short paragraph says section 1128C3B of the Act provides that the minimum period of exclusion shall be not less than 5 years. So anyone who's placed on the exclusion list for whatever reason, they're going to be on there for at least 5 years, correct?
Correct.
It says your period of exclusion is greater than that because our records contain evidence of the following circumstances. If you flip over, 1, the acts resulting in the conviction or similar acts caused or were intended to cause a financial loss to a governmental agency or to one or more entities of $50,000 or more. And then in the last sentence of paragraph 1 states the court ordered you to pay approximately $1,941,200 in restitution. Okay, so that's the first factor that OIG lists as an aggravating factor is the extent and amount of the healthcare fraud and the amount you owed the government. Correct?
Well, I think they forgot to list my codependents. We're all supposed to pay this amount, not just me.
Right, but this letter is to you from OIG, not to you and your co-defendants. It's to you, correctly?
That's correct.
And it says the court ordered you to pay approximately $1.9 million in restitution.
But my point is that the court ordered me and my co-defendants to pay this amount.
Yes, sir, I understand. This document says you were ordered to pay $1.9 million. I believe the point you're trying to make is that it was joint and several. I understand you're trying to make a point to the board about it being joint liability. I'm trying to make a point to you that it is also several liability, which means that you and each of your defendants owed $1.9 million to the government.
In total.
Yes, sir. But several, that means you, the entire amount could be collected from you.
Right.
That's what
right. I mean, that's true.
Okay. All right. Paragraph 2, the second aggravating factor, the acts that resulted in the conviction or similar acts were committed over a period of 1 year or more. The acts occurred from about November 2011 to about July 2014. Okay, so that's approximately a 3-year period. So OIG found an aggravating factor. This wasn't like just a one-off mistake or a slip of the pen. This was activity that went on for 3 years, correct?
Correct.
3, the sentence imposed by the court included incarceration, 39 months. That's correct. Is it not?
That's correct.
4, the individual, and I am paraphrasing slightly, has been the subject of other adverse action, and that refers to, and the last statement in the paragraph says, the Mississippi Board of Medical Licensure revoked your license to practice medicine. Correct?
Correct.
Did you appeal your inclusion on the exclusion list?
I did not.
Have you asked to receive a waiver of your inclusion on the exception list?
To date, I have not. I am pending my pardon application, and if I am successful, which I expect to be, then that's when I had planned to do this.
Okay. But who are you asking for a pardon?
The president.
Okay. Now, you understand that a pardon is it's a measure of grace. It's not, there's no entitlement to a pardon. Do you understand that?
Certainly, I understand that.
Okay. So it's good to be optimistic, but you cannot tell the board as you sit here today that you are going to receive a pardon for this almost $2 million in healthcare fraud that you committed.
No. And I didn't mean to tell the board that. That's not what I'm trying to say. I'm simply saying I've applied for a pardon. And if I'm blessed to get the pardon, that's great.
All right. As far as the CPAP assessment report, again, it appears your performance, according to CPAP, was mostly adequate, but with areas of weakness. In one place at least, they said that your performance ranged to the inadequate. This assessment was conducted now over 3 years ago. Okay. And you have not been able to practice medicine during that time. So do you not believe there's at least a chance that your skills, your clinical skills, have further deteriorated since 2022?
I mean, that's possible, but what I have done over this period of time, I have been engaged in health education for prevention of STDs, including HIV, vaccine preventable illnesses, and I also serve as the medical director to the coroner's office. I was the elected coroner for Baldwin County for 8 years, and subsequently have served as the medical consultant to that office, and have recently been appointed to be the assistant, an assistant coroner or assistant medical examiner.
Can you hold that position? Is that not considered a public office?
It's not a public office, no.
Okay. So the prohibition on convicted felons, preventing them from holding office, that doesn't apply to this appointment.
That's correct.
Do you not feel that it would give the board a better idea of your clinical abilities at this time if you underwent an assessment again?
Well, probably would, yes.
All right. Let's finish up. Count 1 of the order for show cause states that you're guilty of committing a felony involving moral turpitude. Is that true or false?
That's true.
And so you admit that. Count 2 states that you do not possess the good moral character required of applicants for medical licenses. Do you agree or disagree with that?
I disagree with that.
Okay, please explain to the board why you disagree with that.
Well, I had said earlier that I made some mistakes in my life, mainly because of my lack of understanding of the laws. I was naive, thinking that the hospice director was doing legal things and doing the right thing. And I take some fault because my greed and selfishness allowed me to be pulled into their scheme. But as I mentioned, I was simply one of their pawns.
That's not what the documents from the court and your guilty plea represent. They state that you knowingly and willfully participated in this scheme. Do you agree with that or disagree?
Well, I think I told you my attorney suggested that we go this route. And so, again, I don't know all the legal ways of doing things, and I follow my attorney's guide in this instance.
But you were a physician at the time. You were a highly educated person. You had Terrace Harris, a skilled attorney representing you, and you signed the plea agreement that says defendant is pleading guilty because he is in fact guilty. And
That's
you
true.
signed that, did
That's
you
true.
not?
Yes.
Count 3, guilty of receiving final sanctions from OIG. You admit to that because you're on the exclusion list.
That's correct.
Right. Count 4 states that you're guilty of unprofessional conduct. And do you agree or disagree with that?
That's true.
Okay. And just to confirm, the charges about being guilty of conviction of a felony involving moral turpitude in that's 1, and count 4, guilty of unprofessional conduct, those are a matter of record in an order of this board revoking Dr. Brown's license. That's correct, is it not?
That's correct.
I tend to the witness.
Dr. Brown, at this time, I'm going to allow the board to ask you any questions.
Good morning, Dr. Brown. I'm Michelle Owens, Board President. I'm an OBGYN and maternal fetal medicine specialist. So a couple of things. We were provided a lot of documentation today. Can you just kind of give a quick overview for the board of your education and your training? And then I was just noticing and looking through the documents, there's California and other things. So what exactly your Mississippi connection is? Are you a Mississippi native? How did you get here? Can you give us a little background first, please?
Sure. I was born in Mississippi, and in my latter years of high school, I moved to California, where I attended college on a scholarship, academic scholarship. Attended medical school at the same college, and graduated early from medical school. In fact, I got a medical license to practice medicine, temporary license in around March, April 1980, because I'd finished medical school 3 months early. And so I came back and practiced medicine in Mount Bayou, where I was born at. And then I chose to go back and do my residency at Martin Luther King Hospital in Los Angeles, California, for 3 years, and became board certified and recertified on multiple occasions. But my goal was always to practice medicine in Mississippi, because Mississippi has the worst medical care in the nation. And the Mississippi Delta has the worst of the worst. And I had seen that. I had grown up there. My parents lived there. My siblings lived there. And it was my desire to help in any way that I could. And I hope I answered your question, did I?
Yeah, you did. So thank you for that. The next thing that I want to kind of move on to is a little bit of, so we've talked around quite a bit of information, and this board, we, weren't privy to kind of what happened. This was a few years ago. So I understand that you were advised by legal counsel to enter a guilty plea, but what I'd like to hear from you is what do you feel as you look back? You've had a good bit of time to reflect on all of these things, and you've alluded even in your opening statement about, you said selfishness and greed, but that you were kind of unknowingly brought into the situation. When you look back on it, what things did you do that might have contributed to you being where you are? And as you've reflected back on it, were there ever any red flags or anything that you can identify that might have made you press pause or think that maybe this was a deal that might have been too good to be true or whatever? I mean, I'm just trying to get an understanding about kind of what the circumstances were surrounding this whole event.
I'm trying to think if there were some red flags that should have alerted me that some of the things that the hospice directors were doing were illegal. The biggest problem that I look back on and that I possessed at the time was that I was under the impression that if they were doing something illegal, that was for the legal system to deal with, and I couldn't police what they were doing. But had I known that I would be part and parcel of the situation, then I would have refused to participate or simply stop participating as a medical director. And each hospice had multiple medical directors. I was just one of them.
So would you say then that you never knowingly falsified any medical documentation. You never knowingly signed off on anything that was not true as it pertained to patient care during that time?
Yes, I can certainly say that. And let me say this to you. I was the coroner. So many of these people who we were certifying as terminally ill, I certified them as coroner when they died. And when I was not the coroner, and I was elected coroner twice, by the way, and when I was not the coroner, I was the medical assistant to the coroner's office. So I saw a lot of these people die, and the major problem is that they are expected to die within a given length of time. But predicting a person's death is an inexact science. So I can say that this person is expected to die in a certain length of time, but then if the person doesn't die, I'm faulted because I was wrong. But as I mentioned, it's an inexact science. And I know that as a doctor for 40 some years, and as a coroner for 8 years, and assistant to the coroner's office for another 10, 15 years. So predicting when a person is going to die is not something that can be easily done. And unfortunately, as a hospice medical director, hospice medical doctor, we were faulted for not knowing these things.
Thank you for that. I guess the next question, so ultimately at the core of your contribution, what exactly is your perception or your understanding, the way that you would describe what you were accused of? What exactly, what were people saying was the problem? What is your understanding of what you were being accused of doing? Not predicting somebody's date of death, because I think we all know none of us have that crystal ball, but outside of the imprecision of being able to predict when somebody's going to die, what exactly was the real issue with what you were being told was the problem with your contribution here?
Well, what I recall is that the investigators were saying that the medical directors were signing up people who should not have been signed up for hospice, and I never did that. If a person had a illness which could possibly result in their death in a certain length of time, those are people that I signed off on. I can't speak for anyone else, of course. And there may have been some instances where I was misled, misinformed, but I never knowingly participated in an illegal scheme.
So when you said misinformed in what way? Was there clinical information that you were provided that was inaccurate, or help me understand what you mean by misinformed? And I'm not trying to like press too much, but this is your opportunity that you requested to be able to give this board the information that we need to feel confident in whether or not we should reinstate your license. So I just want to make sure that you have an opportunity to kind of clarify any questions that are hanging out there. So that's kind of the purpose. I'm really asking for understanding.
When I say I was misinformed, I'm saying that the hospice owners would tell me that these people were seeking hospice, that they had this diagnosis, this problem, and that they had signed the hospice agreement saying that they wanted hospice and that they were terminally ill or were expected to die within a reasonable period of time, short period of time. And so that's what I mean by misinformed, misled, is that the hospice owners, in many instances that I look back on, basically didn't tell the truth.
So did you feel, were there times when your clinical assessment of those same patients that you were given information about from your, from owners, were these people physicians as well, or no?
The owners are not
Yes,
physicians.
okay.
Only the
So-
medical directors were
Okay,
physicians, and there was
so-
multiple medical directors per hospice.
Yeah, so non-physician people giving you information, did you find situations where your own clinical judgment or your clinical assessment was in opposition to or did not match up with what was being reported to you?
No. That's not what I'm saying. I'm simply saying that in some of these instances, the people who were part of the investigation said that they didn't know they were signed up for hospice, or they didn't know that they had a terminal illness or a terminal illness diagnosis. And that's what I'm simply saying, that the hospice owners misinformed me because they gave me the impression or they told me that these people did know and that these people willingly signed to enjoin hospice. Because you see, an individual who goes into hospice we have to have their permission. A person cannot be on hospice without their permission, just like when you're in the hospital or when you go any kind of medical procedure, you have to sign and agree to that procedure. And that was the case. And now I think what happened in some instances, the hospice owners did not tell me the whole truth. And that some of these people may not have known. And of course, I didn't know because I didn't question them, the individuals. I didn't question them about whether or not they knew what their diagnosis was or knew they were signing up for hospice, because I assumed that the owners had told me the truth. But now, in terms of the medical information, I reviewed that. So I'm not saying that they misinformed me about the medical information.
Gotcha.
I reviewed that myself.
Okay, I just want to be clear. And then, so there's also a mention in the documents about financial incentives. So how exactly did this, like, were you on a bonus structure as a medical director where if you met certain targets, then you were financially incentivized? I'm not trying to dig too deep into your personal financial business, but I would like to understand there's an allegation, or at least there was questions about financial incentives, and you mentioned greed. So can you help me to understand what how there was a financial incentive or how that might have occurred?
Well, that was never a financial incentive for me, and there was no bonuses paid. I simply was on a stipend, which may have been $2,000 per month. And it didn't matter how many patients that I was overseeing or monitoring during that month. It might have been $2,000 per month, might have been $3,000 per month. The problem was, and when I say about agreed on my part, is that the money was too easy. And $2,000, $3,000 a month to monitor these patients. But never did I get a bonus or get extra money for a number of patients signed up. That never happened with me. Okay. But the old accent that says that if it's too good to be true, it probably isn't true. And so $2,000-$3,000 per month. I can remember when I first started doing treating hospice patients back in the early 2000s, when the first lady presented a contract to me for $2,000 a month, I was shocked. It was a struggling physician in Mississippi Delta, barely making ends. And the hospice medical director came to me and asked me to be one of her medical hospice owner, to be one of her medical directors, and offered me a $2,000 check per month. It was too good to be true, too easy to make.
So what was your level of interaction with these patients at this hospice facility as the medical director? Did you round on them once a week, once a month? Did you ever see and provide clinical care to these patients, or was it a situation where you just kind of signed off on orders and, reviewed a census? What was your day-to-day work like as the medical director during your tenure?
Well, all the patients that I signed off on, I saw them because nearly all of them wanted to come to see me as their primary care physician. And at one point, I was an inpatient hospice medical provider. And I saw these people 2-3 times per week. But the ones that I saw as outpatients, it was probably maybe once a month. Now, there were others that I signed off on, and these were when I was co-signing for medical. She usually required at least 2 or 3 medical directors to sign. And so I might countersign behind another one or two doctors, but all the patients that I saw, that I signed, that I enrolled in hospice, I was their provider. And the ones that I was not their provider, nearly all of them insisted that I become their provider. And so I saw them usually once a month.
Just want to follow up on one other thing that you said, and then I'm going to give the other board members an opportunity to ask their questions. You, in your opening statement, said that you are starting a new chapter of your life. What exactly is your new chapter? What are your plans? If you are licensed or reinstated, what exactly are your plans going forward? What does it look like for you now, and how are you incorporating what you've learned as you go forward?
Well, if I'm relicensed, reinstated, I plan to practice medicine in Mississippi Delta at Delta Health Center, primarily treating high blood pressure, diabetes, obesity, metabolic syndrome, the chronic diseases that we deal with in Mississippi in general, Mississippi Delta in particular. Also, sexually transmitted diseases, HIV, etc. If I'm not blessed to get my license reinstated, I plan to continue working with the coroner's office as their assistant. And I'm also considering politics. I was the election commissioner for Baldwin County for close to 20 years, the coroner for 8 years. And because I'm still blessed with good health and mental vitality, I'm not ready to throw the towel in yet. So I plan to, if I don't have an opportunity to practice medicine, I'm going to practice politics.
And my last question is, why should we give you your license back?
Well, first of all, because I was an excellent doctor. Despite the few mistakes I made, I was an excellent doctor. My patients loved me. I took very good care of them. I was doctor of the year on at least 2 occasions, medical practitioner of the year from Mississippi State Medical and Surgical Association. And I can remember when I was an intern, I was intern of the year at my institution. And as I mentioned, I graduated from medical school early. So I think she give return my medical license because number one, I practice good medicine. Number two, my patients love me. Number three, there's so many things I can do to help those people. Because as you know, we have terrible healthcare here in Mississippi. And Mississippi Delta is the worst of the worst. And so the need is tremendous. And unfortunately, we don't have doctors, nurses, etc., who's willing to supply those needs. I'm one of the few who are.
Thank you for your time. At this point, any other questions from board members?
Hey, good morning.
Dr. Roth?
I'm Randy Roth from CMO at Singing River. I'm also the Assistant Medical Director of our hospice in Jackson County. So tell me your role as a medical director of hospice. Were you doing the face-to-faces with these patients? I'm just kind of confused on how somebody could be in hospice, visit a doctor, and then say they weren't aware that they were in hospice.
Yes, I did face-to-face. Yes, sir. And I can't answer that question because that was between see, as a doctor, I didn't have them sign the papers to get admitted to hospice. That was done by the hospice owner or an administrator. As the medical doctor, I simply took care of their medical needs.
When you went to see the patient, you never said, I'm Dr. Roth, part of Delta Hospice, here to see you because I heard you were assigned and admitted to hospice of the Delta?
Oh, yes, sir. Yes, sir.
But the patient still didn't know.
Well, if I talked to them, they knew.
Okay. So when you'd sign off on these patients, you were never aware that they were asking you to do something that you thought was fraudulent.
No, that's correct. No, I was never aware of that.
So you never saw a patient. Did you ever say a patient wasn't hospice ready and tell them they need 6 more months at home? Did you ever see a hospice patient and say, I disagree with the director and this patient is not hospice appropriate.
Oh, yes, sir.
Okay.
Yes, multiple cases.
So at no time during your medical directorship role, you were aware of any fraudulent activity? Because I'm well aware of the competitiveness and the lucrative side of hospice. It is that like that. So you're telling me and the members of the board that you were never aware that anything was going on fraudulently at your level.
That's correct.
And your role as medical director was a separate inpatient hospice facility, or were you managing home hospice, or a combination of both?
A combination of both.
So tell me about was the inpatient facility what we call GIP now, which is inpatient without walls, or was it a separate facility just taking care of hospice patients?
It was separate facilities with simply hospice patients.
And what was your average daily census at that building, ballpark?
And I would say about a dozen.
And were you aware of any of the life expectancy of these patients? Did you ever get a quality review from your hospice company saying, hey, we have 12 hospice patients and we've had 7 of them in there for 8 months? I mean, was a lot, because I think my point, I think our president was hitting at was, at what point did you begin or never realize that something wasn't right about this? There's a hospice patient who's getting hospice benefits for 7, 8, 9 months or even longer than that didn't qualify medically to stay on hospice. I mean, did you ever suspect that, man, this patient's been on hospice for 1.5 years?
Well, there were occasions when I did see situations like that. Yes, sir.
And did you do anything about that?
Well, I would talk to the owner about it and ask why is this person still enrolled in hospice over this extended length of time.
So the last time you did any clinical hands-on family medicine work, it was
17.
I'm not sure I understood some of the paper. So am I under the understanding that if you would get your license back and have a family practice in the Delta, that you'd be excluded from being reimbursed by CMS for how many years?
I'm sorry, say it again.
The document from CMS, they're precluding you from being paid by CMS, which I would assume is Medicare and Medicaid, for how many years moving forward?
Well, I think he showed me 20 years. Was that correct?
That's correct.
I saw a minimum of 5 years.
Okay.
And I think he said another one was 20 years.
So I guess my question is, in the Delta, I would have to imagine your payer mix is in the 80 to 85% CMS ballpark.
Probably close.
So
But if I was blessed to get my license back, I would appeal or try to get CMS approval. And particularly if I'm blessed to get a pardon as well.
but if you're not blessed to get a pardon and get the appeal overruled, you think the numbers add up that you could practice in the Delta and not receive any reimbursement from CMS? I mean, how would you manage an office like that?
That's an excellent question. But now I would be employed by it's called a FQHC, Federally Qualified Healthcare Center. And then we have a whole large number of patients who have no payment. We see people regardless of ability to pay. And some people don't have Medicare, Medicaid, or insurance. Some people are what we call direct pay or indigent. And so those people need care as well.
That's all thank you.
We mentioned earlier, Dr. Joyner is with us today. Dr. Joyner, I'm just saying your name to acknowledge your presence and see, did you have any questions?
Yes, ma'am, I do. I have one. You made the statement earlier that you initially were approached and offered $2,000 a month. That immediately registered in your brain as a red flag. It sounded like what you were describing was a red flag. You were concerned that that was an awful lot of money to be doing what you were doing. Am I not correct there?
Yes, sir, you're correct.
Okay. Did you do it?
I did.
You did. Why would you do it if your brain was saying, maybe I shouldn't be doing this?
Well, at the time, I felt like that was the going rate. And so, plus I did not see any illegalities about serving as a medical director and at a stipend of $2,000 per month.
Did you not feel that at a rate that threw up red flags in your brain that kind of made you under the influence of the owners of the hospice?
No, sir, no, sir, because I have my own mind, and so if they paid me $2,000, that was not going to influence me to do anything, particularly anything wrong, because that wasn't enough money to do wrong regardless.
And I mean, it just seems to me if all of a sudden I started making a pile of money, that somehow that pile of money would influence me to make the decisions in favor of whatever entity I'm servicing. But that's just me. Anyway, thank you.
Thank you.
I'm from the Delta. I grew up in Greenwood.
Okay, great.
Any other question? Dr. Loper? And then Dr. Lippincott.
Dr. Brown, I practice family medicine too in Jackson. So what formal hospice training have you had?
Formal hospice, I've not had any formal hospice training.
So when you were approached to be a medical director, you had not had any hospice training at all?
That's correct.
Was there did you take any kind of CME classes or anything on it before, after you got started?
Well, I took numerous CME classes. I don't recall taking any specific to hospice though.
Okay. That's all I had.
Dr. Lippincott?
Thanks, Madam President. Good morning, Dr. Brown.
Good
I'm
morning.
Ken Lippincott. I'm a psychiatrist from Tupelo. I'm not real familiar with hospice. Thank you. But what sort of diagnoses were common for these hospice patients that you admitted?
Congestive heart failure, chronic obstructive pulmonary disease, coronary artery disease, chronic kidney disease.
Okay. And what was do you have any idea about the average length of stay for these hospice patients?
I can't answer it because I don't know.
Yeah. In the course of my practice, I've seen some people on hospice for dementia. Did you see much of that?
Yes, sir. I did see that. Yes, sir. For Alzheimer's disease, dementia. Yes, sir.
But you never know how long somebody's going to live.
No. As I mentioned, predicting viability in life is an inexact science.
Were you on call for this hospice job, the medical directorship? Did you have to were you on call for that?
Yes, sir. Yes, sir.
If
they had problems, I'd have to make house calls sometimes. And if they had problems, yes, indeed, they would.
Would you bill for your visits on those occasions?
No, I did not. No. If they were part of hospice, the hospice organization absorbed all the medical costs. And so I did not do any individual billing.
Okay. And were you compensated for being on call? Oh, that was part of your stipend.
Yes, sir. That was part of the stipend.
Okay. Did any of the other hospice directors get in trouble for this?
Medical directors?
The medical director?
Yes, sir.
Yeah. Anyway, that's all I have. Thank you.
Thank you.
Any other questions from members of the board?
Counselor.
Was the judge who accepted your guilty plea Judge Neil Biggers?
That's correct.
Okay. Now, you have told the board that you were naive, apparently unworldly, weren't aware of what was going on. Yet then you also described how you graduated from medical school. Was it 3 months early? Or was
That's
it 3
correct.
years? So you graduated from medical school early. You were board certified, And yet you were so naive that you certified patients as qualified for hospice care and never understood that some of those patients weren't qualified?
No, I didn't say that.
Okay, well, then please explain, because I thought you were saying that you never knowingly certified anybody for hospice who wasn't qualified for hospice.
That is what I said.
But you blamed it on your naivete, that you didn't know what the
No,
others were doing.
my naiveness had to do with the fact that I believed what the hospice owners were saying.
Okay. But the hospice owners didn't tell you what the examination of those patients showed, right?
Oh, that's true, but I never said that it had to do with the medical findings. I was simply talking about when people signed up for hospice and when people said they didn't know they were on hospice, that was between the hospice owners. And that was the misinformation that I got, that these people had known that what they were doing.
Okay. But if those hospice owners had not had you certifying those patients as eligible for hospice care, they could not have then turned around and fraudulently billed Medicare and Medicaid for their services, could they? Your certification was a key part of this operation.
That's true.
And excuse me, I'm not a physician, but it's my understanding that at least at the time, hospice patients had to be recertified every 90 days. Is that right?
I believe that's correct. Yes, sir.
Okay. So every 90 days, hospice patients have to be re-examined and recertified that they are still eligible for hospice care, correct?
Yes.
Did you ever recertify any of these patients that were involved in this fraud for hospice care after 90 days?
I recertified numerous patients. I can't remember, but I don't get your question. I'm sorry. You're confusing me.
I'll move on. Dr. Owens asked you a few questions about accusations against you. And if you would, I'd like you to flip back to page in the documents 35. Okay. This is your indictment. And you see right below indictment, it says the grand jury charges that. Then there's count 1, healthcare fraud conspiracy. Do you see that?
Indictment count 1, yes.
Okay. And then if you follow through, you will see that everything before you get to page 40 is part of count 1. And then counts 2 through 6 start on page 40.
Yes, I see that.
Okay. So this is what you pled guilty to, count 1 of the indictment. On page 37, paragraph 11, from June 11th until July 2014, Sandra Livingston through Sandana Hospice and Milestone Hospice submitted claims for reimbursement to Medicare for hospice services that resulted in the total payment of approximately $6,188,211 in Medicare funds to Sandana Hospice and Milestone Hospice, and the payment of approximately $352,074 in Medicaid funds to Sandana Hospice. Paragraph 12 goes on to say, specifically as to Dr. Nathaniel Brown, defendant, Sandra Livingston, through Sandana Hospice and Milestone Hospice submitted claims for reimbursement to Medicare for hospice services related to patients referred to Sandana Hospice and Milestone Hospice by Dr. Nathaniel Brown. The claims submitted for patients that were certified as terminally ill and referred by Dr. Nathaniel Brown result in the payment of approximately $1,900,041 and $252 in Medicare funds to Sandana Hospice and Milestone Hospice. Okay, so that's describing the process by which the money was received by the owners and how the process it went through. At the bottom of that page, paragraph 13, from on or about November 2011 through or on or about July 2014 in the Northern District, Mississippi and elsewhere, defendant Dr. Nathaniel Brown did knowingly and willfully conspire and agree with Sandra Livingston and Laura Lynn Thompson, who are not charged in this indictment, and others known and unknown to the grand jury to execute a scheme and artifice. And it goes on to describe obtaining money and property by false and fraudulent pretenses. And when you pled guilty to count one, you were pleading guilty to those factual allegations. And they state that you knowingly and willfully participated in this scheme. That's what this document says, doesn't it?
That's what it says, but I did not willfully and knowingly do this.
Okay. Look on page 38. Paragraph 14. It was part of the conspiracy that Dr. Nathaniel Brown certified numerous patients as terminally ill and qualified for hospice, when in truth and in fact, the patients were not terminally ill and did not qualify for hospice care. At the time he certified the patients, Dr. Nathaniel Brown knew that Sandra Livingston would submit false claims to Medicare and Medicaid and receive payments from Medicare and Medicaid based on his false certifications and referrals. Now, that's an accusation in the indictment. The next page, you were asked about financial incentives. At the beginning of page 39, there's a reference to payments of $47,750 in checks plus additional payments in cash paid to you. And the statement that each payment to Dr. Nathaniel Brown was a separate overt act in furtherance of the conspiracy. You see that accusation?
Yes, yes. Now, keep in mind, this is over 4 years. That was the amount that was paid to me over 4 years.
Yes, sir. Now, if you turn to page 51, this is your plea agreement. And I'm not going to read the whole thing, but are you on page 51, paragraph 1?
Yes, sir.
The defendant agrees to plead guilty under oath to count 1 of an indictment, which charges that the defendant, Dr. Nathaniel Brown, did knowingly and willfully conspire and agree with persons known and unknown to the grand jury to execute a scheme and artifice affecting interstate commerce to defraud a healthcare benefit program, that is Medicare and Medicaid. And it goes on. That's in your plea agreement. That is what you pled guilty to under oath to Judge Neil Biggers, correct?
Correct.
Are you trying to tell this board that if you had told Judge Neil Biggers that the facts were wrong, that you had never knowingly done that, are you trying to convince this board that Judge Biggers would have accepted your guilty plea?
No, what I'm saying is that my attorney counseled me that this was the best way for me to proceed, and that's what I chose to do.
And do you understand that regardless of whether you are now, you're saying you relied on the advice of counsel, it's great that you had an attorney at the time who did advise you. But even if you relied on the advice of counsel, this document is you under oath stating you are guilty of the accusations in the indictment. Do you understand? The fact that your attorney recommended that you sign this as the best deal for you does not change your guilt or your guilty plea. And then the last sentence of the plea agreement says the defendant is pleading guilty because the defendant is in fact guilty. Do you understand that you are in fact guilty and have admitted that you are guilty regardless of your reasons for pleading guilty? Do you understand that?
I do.
I got one question for you. What type of facility was it that you said some type of federal facility that you would work at in the Delta if you got your license back?
Delta Health Center.
What?
Delta Health Center, and it's part of the federally qualified healthcare system.
Okay. Do you know whether that facility as part of the federally qualified healthcare system would fall under the exclusion? Because as I understand it, no federal funds from any source can be used to pay for any services that you provide. And that would include like providing a facility where you work. That's my understanding. I'm asking, is my understanding correct, or do you know anything about that? Have you discussed that with anyone?
I don't know.
Thank you.
Do the board members have any follow-up questions?
One more question. Dr. Brown, do you have a preliminary agreement with the people at the Delta Health Center? Like, have you spoken to them? Have you had conversations with them about potential employment opportunities, or is that just an aspirational goal?
I've had numerous conversations. In fact, Mr. Fairman, my CEO, has submitted information to this board about my work there and my prospects of getting a job there. As a matter of fact, I wish I could find it for you, but it's from Mr. John Fairman. He's CEO at Delta Health Center, and he sent in multiple letters saying that I would be employed there.
Thank you.
Thank you.
Any other questions? Okay, you may be excused.
Thank you all.
Thank you.
I'll waive any closing statement.
Dr. Brown, do you have any additional witnesses that you would like to testify today? Okay. Council waived any closing statements. Would you like to give a final statement to the board? If so, you can stand at the podium and do so.
I just want to thank you all for your time. Appreciate you.
Thank you. This concludes the hearing in this matter. I will turn this matter back to Madam Chair.
Thank you, Madam Hearing Officer. All right, so board members, we have now heard all of the information from the licensee as well as the attorney's perspective. And you've had an opportunity to ask any questions. So at this time, I am willing to entertain a motion.
Second.
It's been moved and properly seconded that we close the meeting to consider whether to go into executive session. Any further discussion on that? Hearing none, all in favor? Aye. Any opposed? Thank you. Meeting's closed. Let everybody. All right, so we are back in open session and Dr. Lippincott, the Vice President, will give the decision from executive session.
In the matter of the show cause hearing for Dr. Nathaniel Brown, the board has made the decision to approve a conditional restricted license, conditional upon completing and updating a CPEP evaluation. He is restricted from working in home health, hospice, or collaboration with APRNs. He's to complete a board-approved ethics course, and he shall complete a board-approved reentry program. Upon completion of all these requirements, Dr. Brown may repetition the board in no less than 1 year. And if you have any questions, please contact the board, and the executive director can give you further guidance. Dr. Brown.
Thank you. We are going to move on to the next item of the agenda for this morning. Let me find my agenda. I got it. Third page. Which is a hearing in the case of Dr. Harold Lee Pelton, license number 2927, Cleveland, Mississippi. It's 20, tab 20 in your binder. But the information, we also have the exhibits and information are also on your pad, on your Surface Pro. You can tell I'm a Mac and not PC.
Madam President,
On your tablet.
Madam President,
Yes.
this is Tom Joyner. I'm going to have to recuse myself in this matter. I've done some investigation in this matter very early on.
Okay. Thank you, Dr. Joyner.
Thank you.
I would love to tell you could just have lunch early, but all right. Yes. And just for the record, despite Dr. Joyner's recusal, we still have a quorum.
Yes, you may proceed.
Can you turn on your microphone, Paul? Thank you.
This is Dr. Pelton. This is Dr. Tom Kirkland. Mr. Tom Kirkland, his attorney. Thank you. Mr. Kirkland and I have conferred, and we have agreed to allow the exhibits to be entered at this time. And without any objections, I will like to list mine for the record and allow Mr. Kirkland to do the same, just in case he wants to call them something different. My exhibits, beginning with MSBML 1 through 4, is the corrected summons and certificate of service. Pages 5 through 7 are the affidavit. Numbers 8 through 9 are the complaint. 11 and 12 are simply some communications between Mr. Kirkland and myself. Mr. Kirkland had asked for a continuance in accordance with the rules. That was passed, that was sent to Dr. Owens, and Dr. Owens denied that motion because he had already received a continuance for the November hearing. Okay, page 14 begins a petition to enter plea of guilty. And that goes through page 17. Page 18 is a begins a transcript of the guilty plea and sentencing hearing. Dr. Pelton, and that goes through page 47. The next exhibit, base numbers 48 through 50. This is a non-adjudication order and dismissal of multiple counts of the indictment against Dr. Pelton. Pages 51 through 53 are forms from the Mississippi Department of Corrections regarding the manner in which the charges for which Dr. Pelton had been indicted were resolved. Page 54 is a printout from the Office of Inspector General of Health and Human Services. This printout was actually printed on December 26, 2024, indicating that Dr. Pelton is on the exclusion list. Now, base numbers 55 through 62. This is actually Dr. Pelton's answer and defenses, but I'll go ahead and offer that as a part of the record. And then I'll let Mr. Kirkland list his exhibits. Okay. And first, I'd like to ask, you have no objections to any of our exhibits?
I have no objection. Thank you, Paul. My name's Tom Kirkland. I'm with the law firm of Kirkland and Simpson. We're in Ridgeland, Mississippi. We practice generally in the area of healthcare, have done so for quite some time. I understand that y'all have copies of my exhibits. I'm afraid I don't know if there's a number that's been placed on the bottom of yours, but I can tell you, I'll just run down. If there's a question, please ask me about them. Our exhibits are in letter order. Exhibit number A is a letter from the Office of Inspector General dated January the 31st of 2024. That's our number A.
Mr. Kirkland, if you'll give me just a moment to the board members, if you look at the exhibits, there's the exhibits for Dr. Pelton. It says Pelton licensees exhibits is the PDF that he's referring to. It's an 80-page PDF. So you can follow right along, and it starts with that document that he just mentioned.
Thank you very much. A is the January 31st letter from the Office of Inspector General. Number B is a appeal notice that was filed. It does show Butler Snow. I was with Butler Snow and moved to a different law firm, so I don't want to confuse you by that. But that is an appeal of the exclusion that was filed in April of 2024. Number C is the decision of the OIG administrative law judge. Very important to our case. So you'll hear me refer to Exhibit C a number of times. Exhibit number D is the letter dated May the 14th, 2014 from Advanced Med regarding a post-payment review of what was a ZPIC audit. If y'all are familiar, I think you would be with the ZPIC audit. Number E is the a letter addressed to Arnold and Porter in Washington, D.C., which is an appeal letter to CMS concerning the issues involving the billing that Dr. Pelton did that ultimately resulted in this case. The letter F is a letter from Treasurer Tyson to Dr. Harold Pelton in September of 2016 on stationery from Jim Hood. The next document is G, and that's the 16 count indictment that the Division of Medicaid filed in Bolivar County. Number H behind that one is just a list of the claims and the charges that were made that correspond to what was in the indictment that was listed. Exhibit number I is a petition to enter a plea of guilt that Dr. Pelton executed. I'll talk much more about that later on, or Dr. Pelton will, especially the matters that are underlined. Exhibit J is a page out of a transcript between the circuit judge of Bolivar County and attorney Derek Simmons. Number K is the non-adjudication order that was signed by Judge Webster in Bolivar County, non-adjudicating the case against Dr. Pelton. And the last exhibit L is a draft of a request to the Office of Inspector General for a waiver of the exclusion that the OIG levied against Dr. Pelton. And I say it's draft because we were in the process of, it has to be, these waivers have to be signed by a person who is in charge of a federally administered governmental program. So we were in the process of getting the director of the Division of Medicaid to sign this just about the time that he went out of office. So I got caught up in the change of Mr. Drew Snyder, who went to work where I'm not really sure, but I understand he's being interviewed in Washington. So I don't think I'm going to get Mr. Snyder to sign this, although I wish I could. No, but this is just a draft, and that we're talking to federal agencies right now, or state agency heads, to get this waiver signed. I feel like we'll get it signed. Those are our exhibits. Any questions? Thank you.
No
Bob?
objection.
Objection so admitted at this time.
May I proceed with an opening statement?
Yes.
This case is a lot simpler than Dr. Pelton and his attorney are going to make it. I mean, these are the facts. Dr. Pelton was investigated for billing practices back in the 2013 to 14 timeframe. Dr. Pelton, the audit showed that he had billed for services that were not permissible more times. The window was 90 days. Dr. Pelton had billed some of these procedures every 10 days. Eventually, he was not criminally prosecuted by the federal government, and Dr. Pelton paid a substantial amount of restitution to the Department of Medicare, to HHS and Medicare, which was several $100,000. I'll go into the details of that with Dr. Pelton. And that concluded the federal investigation. Okay. Then on behalf of the Department of Medicaid, there was a state investigation. The Attorney General's office chose not to simply accept restitution. The Attorney General's office sought and obtained a 17-count indictment against Dr. Pelton for Medicaid fraud. Eventually, Dr. Pelton and the Attorney General's office reached a plea agreement by which Dr. Pelton would agree to plead guilty to one count of the indictment. Now, it is important for the board to understand that when someone pleads guilty, they are admitting the facts of the indictment. They are admitting guilt. Now, the complicating factor here is that Dr. Pelton also requested, and the court granted, a motion for non-adjudication. So you have to plead guilty first, or offer a plea of guilty to the court. Then the court can, in its discretion, and if it complies with the relevant statutes, agree to withhold acceptance of that guilty plea, which means that the person is not convicted of the crime. The judge in this case agreed to non-adjudication and required as a condition that Dr. Pelton complete 3 years of unsupervised probation. That 3 years has not yet expired. Now, up to that point, it's pretty straightforward. Here's where it gets a little more complicated. Dr. Pelton then received a notice from OIG that he had been placed on the federal exclusion list for federal programs for a minimum of 5 years. That is because under their rules and regulations, the Office of Inspector General does not treat non-adjudicated pleas any differently than any other plea. If you go into, and the actual language is in the decision of the ALJ, but essentially it means if you don't plead guilty, or if the adjudication of your charges is withheld, it is still a basis for exclusion and placement on the exclusion list. That's what Dr. Pelton falls under. Dr. Pelton, the guilty plea was non-adjudicated. He's currently serving, as I understand it, 3 years of unsupervised probation, and he is on the exclusion list. Now, you heard Dr. Pelton's counsel say, or if he didn't say, I know he's going to, they said in their answer that one, they're going to ask the judge to expunge the criminal proceedings. But those proceedings have not been expunged at this point. Asking for something, having it done are two different things. They appealed Dr. Pelton's inclusion or addition to the exclusion list, and the ALJ for OIG said, this looks like nothing more than a billing mistake to me, but the rules are clear. This is a ground for exclusion. I have no choice but to uphold it. Dr. Pelton also, or his attorney, says that they're trying to get an exemption or an exception from OIG, permitting him to receive payment from federal, despite the inclusion, basically to grant him an exception to that. However, that hasn't happened yet. Bottom line, and this is where I hopefully get simple again. Bottom line is there are two charges against Dr. Pelton in the affidavit. One, there's nothing about a conviction of a crime. We didn't charge Dr. Pelton because, again, technically, he has not been convicted of a crime. We charged him with having received final sanctions from a federal agency, in this case, OIG, by being placed on the exclusion list. And we've also charged him with unprofessional conduct. There's a separate section of the code, a separate subsection of section 29, 73, 25, 29 that says that if you violate any other provision of the rules or regulations, it is deemed to be unprofessional conduct. And that has been the historical treatment of this board. So the unprofessional conduct charge is based on the fact that he did violate another statutory subsection. Those are the facts. And of course, it is within this board's sound discretion as to what action to take. Thank you.
May I proceed? Thank you. The case is the facts of this case are in some respects simple. I don't appear before this board very often. It's not that I don't like y'all. It's just that other people in my office do. Sometimes I get a case and I feel like it's a case that at my age professionally offends me. I'm professionally offended by this case, not what y'all have done, but what took place with regard to the OIG, what took place in Webster County, which I think is a travesty of justice to Dr. Pelton. Dr. Pelton has not been charged with being a bad doctor. He's not been charged with providing unnecessary services. He's not been charged with providing charging for services for which he did not pay, which he did not perform. This is strictly a case where we are caught up in an issue here with the OIG and a law from which they don't believe they have any remedy but to levy an exclusion. You have this case today by virtue, as Paul was saying, of section 7325-127 of the Mississippi Code, which gives you the authority when you consider the granting or rescission of a license, that there are certain grounds you can deny a license on, and one of them happens to be an exclusion. So to answer everything here, you can restrict a license, you can put one on probation, or you can do nothing. And to me, this is the case where the Board of Medical Licensure should be doing, frankly, nothing with regard to this exclusion. Yes, we have a waiver. That's why I put the draft on there. Yes, we intend to file it. And I'm going to, I've always said this about lawyers. I don't like lawyers, first of all. Y'all probably don't either. I don't care a lot for lawyers. I don't care a lot for what lawyers' opinions are. I care for what my opinion is, but I don't care for other lawyers' opinions. But what I care about are what documents say. And if you want to know where something stands, look at the documents. And here's what the documents say. And Exhibit C is the one that you want to look to, because it's the appeal from the department to the appeal order from the OIG. Now, this is not me saying this. This is not anybody in Mississippi. This is nobody in connection with Dr. Pelton. This is the person designated by OIG to hear an appeal of an action taken by the OIG. And when I look at this, I would just call y'all's attention, and I think as part of the opening statement and the questions you may have for him, take a look at what is page 4 of Exhibit C. And this is the administrative law judge talking. And she talks about petitioner was convicted of a criminal offense within the meaning of the act. And I want to talk to you about what he was convicted of in a moment. But she says conviction for purposes of mandatory exclusion is defined by 42-13-20A, and it goes on. Irrelevance here includes, convicted includes when the individual or the entity has entered into participation in a first offender deferred adjudication or other arrangement or program where the judgment of conviction has been withheld. And she gives a cite. And she talks then about the circuit court's opinion. And she said the circuit court's non-adjudication order falls within this definition. And to that, Paul's right. It does. The circuit court withheld accepting the plea, meaning the judge didn't accept the plea of guilty. But he said he withheld that pending the petitioner's ability to successfully meet 3 years of unsupervised probation period. And he has so far done that. If he fails to meet that, then the circuit court without notice will accept the guilty plea. So OIG acknowledges that the OIG did not accept that. She goes on to say on page 5, at times the definition of conviction for purposes of the act is broader than the analog found in the laws of certain states, as appears to be the case here. See Mississippi Code 99-15-26. This can lead to an outcome where a petitioner unwittingly pleaded guilty to a criminal offense under a state deferred adjudication program or something similar where judgment is withheld pending the fulfillment of certain conditions of the state, believing that the plea will not impact their ability to receive payment for treating federal health care beneficiaries. And had they known that this plea would qualify as a conviction for purposes of an OIG exclusion, they might have opted to go to trial, as the petitioners have credibly asserted. I, however, do not have the authority to vacate the petitioner's plea and the resulting non-adjudication order, regardless of how compelling the circumstances. She goes on in here, and she makes a lot of other statements that I do recommend that you read from this. And she even talks about regrettingly, she says on page 6, therefore, I regrettably must find that the petitioner was convicted of a criminal offense within the meaning of the act. Now, I read all of this to the OIG administrative law judge saying, I'm sorry, you didn't do anything. You probably shouldn't have been convicted. You shouldn't have accepted the plea. And I'm sorry I have to do this. And the last thing I want to point out to you in this order is the footnote. I don't think I've ever seen a footnote like this in an order from an appellate judge, much less an appellate judge for the Office of Inspector General. She says, as discussed during the pre-hearing telephone conference and included in the Inspector General's brief, petitioner may seek a waiver of exclusion. The decision to grant, deny, or rescind a request for a waiver is not subject to administrative or judicial review. I've got the administrative law judge telling me in this order, you need to file for an exemption to this exclusion. And she's really saying, I think you ought to have one. So that's what I think. While this case may not be confusing, I don't think anything that Dr. Pelton did, and it's easy enough. And I heard the prior case, and I heard the petitioner talk about he just did what the lawyers told him to do. Well, that's true. I know y'all are going to say in every case, but it's true here. Dr. Pelton got a known lawyer in the Delta, Willie Simmons, to represent him. And there's a lot of conversation between him and the judge when they were working on this plea and on this deal about, I want to make sure that he's not precluded from seeing Medicare beneficiaries or his license is any way affected. And he believed that to be the case, and the judge believed that to be the case. And then we get over to the plea itself. And the plea itself is number I, is my exhibit number I. And it's called not a plea, it's called petition to enter a plea of guilty. And it says down in about the third unnumbered paragraph, the facts of this crime committed by me are as follows. Between January of 2011, February of 13, and count 3, one count, I provided medical care billed the Division of Medicaid, but it is disputed whether the billing was proper within the 90-day global period. That's his plea, okay? So at this point in time, he's still telling you this, and when he testifies, I want to make sure, I'll ask him if you don't. The LCDs are being put out, and the information being put out by the government gave no time frame for 10 days, for a 10-day that you could not do something in 10 days, nor did it say you had to do 90. It just like the law does a lot of times. Doctor, go out and provide what's in the best interest of the patient, and you'll get paid. And so there was nothing that he could violate because there was really no order out there. And I'm not telling y'all any of this to try and collaterally attack the exclusion. I can't do that, and you can't do that. I'm going to attack it through the exception, but I'm not asking you to do that. I'm asking you for purposes of his license, that his license should not be restricted and should not be revoked because the man did nothing wrong. And that's the plea. And then we go to the adjudication order, and that's Exhibit K. And if you look at really the last couple of sentences before the portion of the order on the first page that says it's therefore ordering a judge, the court talks about this, and then the court says this: having found so in pursuant to Mississippi Code 99-1526 as amended, the court does hereby specifically withhold exception of such plea and adjudication of guilt thereon, as well as the imposition of a sentence pending successful completion of the conditions imposed herein. And on the second page, I mean, you can look at them. avoid injurious or vicious habits, avoid persons or places of disreputable or harmful character, support your dependents, and then to pay the court costs and to pay a fine of $1,000. And so that's the state court proceeding that we're looking at here. And then finally, if you would like to read the last exhibit, which is L of our submission, you will see that's the request for the waiver of the exclusion that we're going to file pursuant to really the directions of the OIG administrative law judge to get this set aside, in which event he'd be able to bill Medicaid beneficiaries, and this matter would be in essence over with. So we're here today before you on this issue really of what's contained in the state statute, which says which allows and says you may, in renewing a license, take into consideration, and then it lists these things, one of which is a federal exclusion. So you had the authority to act. I'm not in any way disputing that. I'm more asking y'all to refrain. Give us time. We're going to get this waiver. We can get this expunged, I think, quite easily. And we'd have already done that, but we've in the Christmas holidays, and judges and some lawyers don't operate too well during the holidays because for some reason they feel like they don't have to. Anyway, that's my opening statement to you. I feel strongly about this. I feel like Dr. Pelton is a good doctor. I don't know of anything or anybody that I've seen who's been told that he ever overbilled, that he ever provided a service that wasn't needed, that he charged for a supply that wasn't provided, or that from a medical standpoint, he did anything wrong. And I think that's what the board is looking for and should be looking for to protect the patients. And I'll say one final thing. He practices medicine in Bolivar County, in Cleveland, Mississippi. He's the only ophthalmologist in Cleveland, Mississippi. He's the only ophthalmologist in Sunflower County. There are other ophthalmologists around there in some of the counties who I guess could come over there and take that up. But we are in a world of shortage of physicians in underserved areas. And I think the last thing that we all need to do is anything that discourages a physician from coming down and practicing in an underserved area. My hat's off to those people. I think they do that because they genuinely want to help somebody, not because they want to make money, because you can make more money being an ophthalmologist in Jackson, Mississippi than you can in Cleveland, Mississippi. But I just point that out to y'all that he does practice in an underserved area, and I think that practice is important to the citizens. That's all I have to say. Any questions I can answer, I will. Thank y'all.
I'd ask that Dr. Pelton be sworn if he has not been already.
He needs to be sworn.
Raise your right hand. You solemnly swear or from the testimony you're about to give in this call the truth, the whole truth, and nothing but the truth, so help you God.
Yes. Dr. Pelton, would you please take the lips there? Okay. Yeah. You know, and of theirs.
Oh, thank you.
Good morning, Dr. Pelton.
Good morning.
My name's Paul Barnes. I'm the board attorney. I'll be asking you some questions, but I ask that you remember that the board members are both the judges and the jury here. So if you would direct your answers to them. How much money were you required to pay in reimbursement to Medicare over this minor billing issue?
Off the top of my head, I think it was $372,000.
Mm-hmm.
Is that correct?
I think that's close to the figure I saw, and it is in the documents. We could get an exact figure, but that's close enough for me.
Mm-hmm.
So first, to stop Medicare from investigating you on the federal level, you had to pay them $370,000 some odd dollars in restitution.
That's incorrect, sir.
Okay.
I
please correct me.
was investigated, and they cleared me of any criminal wrongdoing, but they disagreed with the use of the modifier. It's a very underserved area with a huge need. I treated a lot of patients, very busy practice treating a lot of patients. So when they said we disagree with the use of the modifier, they go back to every single time that I provided that care that those patients needed, and I provided it in the way that the patients needed it. If that care took over a year to administer, many of them would have gone blind, but I was able to save many of them. We didn't have the technology that we have today. We didn't have the injections and things that help so much. Now I use a combination, well, not this moment, but before it was time to renew the license, combination of the anti-VEGF injections, which is vascular endothelial growth factor injections, and laser. And I do a lot less laser than was necessary before. I was committed to using the less expensive version, which saved Medicaid over $1 million. And I still have the boxes of syringes. My lawyer said, you don't need to bring those, but you should state that. The Delta's a poor place. We have to be very cost conscious. And there was one that cost $40, one that cost $1,400. So I used the one that cost $40. But it's compounded, and we were under an advisement on the national level, don't use compounded medicines, because up in New England someplace, somebody had a compounded steroid they stuck into a spinal column that had fungus growing in it. And the person had a horrible encephalitis, fungal encephalitis, and so forth. And so they said, well, we're going to protect y'all. We're going to come in with more regulations and tighten up on this so that compounding pharmacies are safer. In the meantime, don't use them. So the laser was our only option on that. And we had to do it. And I had to do it in a timely fashion in order to save these patients. And never, I mean, doctors have always been paid for each stage of a stage procedure. And it never was a thought to me that you wouldn't get paid for each stage of a stage procedure. This idea of a global period, okay, that's something. But the global period is, okay, you see him, you do a laser stage, you see him back medically to check on it, you will not get paid for that medical visit. But if you did another surgical intervention, especially another stage, well, that just restarts the clock. And that had been the way to do it. That was the accepted way. Cojaba was the Medicare carrier. They were fine with it. And when Cojaba was fine with it, Medicaid was also fine with it for 3 years. But then we got a new Medicare carrier, which was Novitas. And Novitas said, doesn't matter, 90 days, we're not paying anything. Even if it's completely unrelated and they're supposed to pay. Person had a laser, they come in for foreign body in the eye or allergic conjunctivitis, bacterial conjunctivitis, they're still not paying. Glitch. We've programmed our computers to reject all this. And then they said, it's up to you, doctor, to give us all this documentation within 45 days to get paid for that and prove to us how everything was unrelated. So that's what Novitas was. They were hard. Was there any guidance on this, any LCD or local coverage determination? No. And I've done my best to clarify. I consulted with Medicare, and at first they said, well, we can't advise you on the billing. But in the end, they say, what, if you bill and it goes through, then it's okay. The Department of Medicaid had a liaison, Mr. Flint G. He was out to my office twice, reviewed our billing, said, we're doing all right. He said, if it's getting paid, then that's okay to do it. Just make sure you're doing the right thing for the patients. And I was doing the right thing for the patients. I was delivering. Now, it's all changed. We don't have that time pressure now because we have these anti-VEGF injections. They help so much. And we don't have to do nearly as much laser. I mean, I do less than 10% of the lasers that I needed before because of the effectiveness of these anti-VEGF injections, but they still do require it. Now, could I ignore the anti-VEGF? Yeah, there are ophthalmologists who do that. None of them are being called in front of a board or anything, but because I don't know. For me, making less money was not the purpose. I didn't come here to make money. I came to serve in an underserved area because God put it in my heart to do it. I was a busy LASIK surgeon, one of the busiest in the country, but I was away from home a lot. I wanted to be one place where I could be around my family, raising 4 kids, and really help people that needed it. And we looked all over, my wife and I, up in Alaska, Big Sky country, Indian country, all through the diabetes belt, up through Appalachia, and made a deal to come here. The hospital sponsored me for moving expenses in the first year. So, and then got to work, and I did a lot of work. There's a huge need. The fact that repayment request was so big was because I had done all of that work. I did all of that work in good faith that the patients needed, and then I had to give it all back. And that was heartbreaking. And it wasn't CMS that denied the appeal. It was Novitas, the local Medicare carrier. Whereas Cojava, the previous Medicare carrier, said everything was fine. But Novitas said, no, we don't pay. Well, after that was over, the federal government, after I was insisting, hey, you're going to blind, you've now making me repay that has created a precedent that is going to make every ophthalmologist afraid to give that care in a timely fashion, and patients will be going blind. So what did Medicare do? As soon as I dropped the appeal and they didn't have to worry about giving me my money back, they changed it. Instead of 90 days, it's 10 days, that global period. 10 days is not bad. You know, you could give it every week or two. You do a stage, you have to let the eye recover, then you do some more, whatever the patient can tolerate. Tender patient, you may have to do more stages, but everybody's probably going to get at least 4. And if you have to wait 90 days, it's over a year to get it done, and people would go blind. So in January of 2016, the new rule came out, it was 10 days. But when Medicaid decided to be very aggressive on this, and they filed indictment, it had been 90 days, or 10 days instead of 90 for almost 2 years. But in what they filed in their secret grand jury, in fact, they said it's 90 days, and everybody else in the state is allowed to practice and provide those statements at 10 days. That's a federal law, and Medicaid defaults to it, right? But not me. I got singled out. Nobody else ever had to repay money, just me. There are ophthalmologists out there right now, today in their clinic, doing a second stage of PRP after 11 days. And they're not going to be in front of the board. That's all fine. They're getting paid. So that indictment, by reason of the update in Medicare that came to agree with me, okay, we admit it, those patients do need timely care. They changed it from 90 days to 10 days. Now, they didn't give me my money back. And I asked my lawyers about that, and they said, oh, good luck clawing that money back from Medicare, but be proud that you got it changed. Well, it got changed for everybody else in the country and can get timely care except for my patients. You know, it was a sacrifice for my family to leave a nice neighborhood outside of Cleveland, Ohio, and come to Cleveland, Mississippi. I checked into a hotel last night to be here in the morning, and I had to do a little shopping. I was amazed. Everything's there for you here, right? It's not like that in the Delta. And doctors don't want to live there, and doctors' wives don't want to live there. And I wanted to show my family, my children, that service matters. I don't only provide medical care, I don't only provide charity medical care, of which I've done over $2 million since 2010 when I got there. I'm involved with disaster relief, and I helped bring our county disaster relief volunteer agency from last place out of 82 counties where they had 0 projects done to first place where we get them all done. And that first year we got 29 done, and we set a record for getting it done with the most accountability and the least cost.
Excuse me, not to cut you off, Dr. Pelton. I do believe that council is ready to proceed. The board will have an opportunity to ask you any questions as well as council. And so at this time, I would ask that council proceed with his questions at this time.
Oh, yes, ma'am. I apologize. I was just trying
That's
to
okay.
say, I want to set an example for my children. Live modestly, do charity, live it. Because what you say to your kids is one thing, and what you do, they see, and it's very impactful.
Thank you, doctor.
Thank you.
All right, so doctor, if I misspoke, I appreciate it. I believe my question was that whether you had paid restitution to Medicare and that it concluded the investigation, and you corrected me that had not in fact been the case, but that you had reimbursed someone, paid back $370-something thousand for federal issues related to your billing. Is that
That is
fair?
correct.
Okay.
But
How much?
That was after they'd said, we investigated you and you didn't do anything criminal, but we want some money. And I think it's important to know that the ZPIC has a financial incentive. When the agency was created, they get to keep a percentage of that money that they ask for. And I don't know that exact percentage, but it's roughly a third, I think.
Move to strike is non-responsive.
Any objection, council? So strict.
He just moved to strike. He's saying that my answer wasn't responsive to his answer. I just want to say, look, it was not an attempt to avoid investigation. I got investigated and I got cleared of any criminal wrongdoing.
Dr. Pelton, again, I'm going to ask that you limit your responses to council's questions.
Yes, ma'am. But I also had to promise to tell the whole truth. And characterizing the payment as avoiding an investigation is flat wrong. And
Doctor, did you repay any money to the State Department of Medicaid?
yes, sir,
How much?
150,000.
And I'm not sure whether you've had the opportunity to review the transcript of your plea hearing. Have you ever seen that transcript?
I have not, but I was there.
Right. Well, that's going to be my next question, but you were there. And do you remember that the judge explored with you whether or not there was a factual basis for the plea? Do you recall any of that discussion?
No, but I'm sure you can help me.
Well, I'm sure your counsel is gonna cut me off if I go too far, but my understanding of the criminal process in Mississippi is that a judge cannot accept a guilty plea without determining if there is in fact a sufficient factual basis for a finding that the defendant might actually be guilty of that offense. And the transcript shows that the judge here made that determination and accepted your guilty plea for the initial purpose. Excuse me, sir, please. I don't want to have to read 3 pages of the transcript.
Well, let me object to it because I don't think the judge accepted the plea.
All right.
It says
Give
in
me
there,
one moment.
he
please.
specifically did
Dr.
not
Pelton,
accept the plea.
there's an objection and I have not ruled on it yet.
Oh, I'm sorry.
Thank you.
And as to his objection, I'm not saying that the court did not grant the motion for non-adjudication. However, before the judge could get to that point, the judge had to receive from Dr. Pelton a plea of guilty. And then he had to make a determination whether to non-adjudicate the case.
Objection is overruled.
Well, I'd also like to object the fact this witness doesn't know what the courtroom procedures are and whether or not what Paul said is true or not about what the court has to do.
Yes, but the witness was there and I believe counsel is asking him what his role was at those proceedings. Your objection is noted for the record, but it's overruled.
Thank you.
Okay. And again, I don't want to belabor this point too much, but start on page 27, base number 27. This is from the Senate guilty plea and sentencing hearing from May 10th, 2023. The court says, Dr. Pelton, you understand that this is the charge to which you're tendering your plea of guilty. You understand that, sir? Yes. Then he asks, let me ask Mr. LaBar, and then he goes into a discussion of, does the state have any objection to the doctor making an offered plea or a best interest plea? And then they go through a discussion as to whether or not you are admitting your guilt or whether you could make a plea simply saying it's in your best interest. Okay. Finally, on page 28, the bottom of the page on line 21, the court says, all right, well, based upon what I've heard this far, and notwithstanding that it is a best interest plea, the court will find there's a factual basis at least upon which the plea may be considered, may be tendered, may be entertained by this court, and upon which, if the court determines to do so, would warrant the acceptance of the plea by the court. And then the court says, I understand that this is an open plea. You need to understand, I guess, that the vast majority of people that plead guilty in front of me, or any other judge for that matter, when they do plead guilty, the state of Mississippi will recommend a particular sentence that might be imposed upon that individual. And we call that a recommended plea. Now, he then goes on to explain that an open plea simply means that he can order anything he likes. There is no recommendation, there's no guarantee. And he asked if you understand that, and you answered yes on line 23. And he says, that means based upon your plea here today, if the court elects to, it may accept your plea of guilty and sentence you appropriately accordingly. You understand that, sir? Yes. Do I understand that the maximum sentence is 5 years in prison? Yes, sir. And he says, he asks about a minimum time, and then he gets down to line 18. Dr. Pelton, then you need to understand that following up on what I said earlier, if I were to determine to not non-adjudicate you, but rather accept your plea of guilty, I could today sentence you up to 5 years in the state penitentiary and not suspend a day of the time and fine you up to $50,000 and not suspend a dime of the fine. You understand that, sir? Yes, sir. Knowing those things, do you still want to tender your plea of guilty to this court on count 3 of this indictment, sir? Yes. The court then goes on to describe the rights that you give up by making a plea. Now, after that, the court does then say, I'm going to withhold acceptance of this guilty plea that you had made to him, unadjudicated. That's why I have never said that you are guilty of being convicted of a crime. And I'm not saying it now because that guilty plea was withheld. However, OIG takes the position that when you make an admission of fault, even if the judge non-adjudicates it, as far as they're concerned, it puts you on the exclusion list. And you understand that based on the rulings OIG has made so far, correct? You understand that's their position.
I understand that now. I did not understand that at that time in court. In fact, I had been told the opposite by my attorney.
Okay. Well, whether or not you might have issues with your attorney is beyond the scope of this hearing, and I can't comment on the legal advice you were given. But you do agree that the terms of your non-adjudication, first of all, do you recall that the judge noted that you had repaid the state $150,000? Do you remember that the court
Yes.
said that, right? And the
Yes.
court mentioned that was a factor in his decision. Do you recall that?
Yes.
Okay. All right. And then the court said, well, I'm going to grant the motion for non-adjudication. I'm sentencing you to 3 years of unsupervised probation, correct?
That did happen. Yes.
Yes. And that was back on May 10th of 2023.
That sounds,
I will represent to you. That's what the transcript shows.
I believe you. That sounds correct.
Okay. So your 3 years of unsupervised probation will expire sometime like May 9th or 10th, 2026.
It's a little more than half over unless we get an expungement granted earlier, which my attorneys have told me is extremely likely.
Right. But
But hasn't been done yet.
But you understand that statements of counsel, arguments of counsel made to the board or otherwise are not evident. They are not evidence. They may not be given. The fact that your attorney says, we feel really good that we're going to get an expungement, that's not evidence that the board can rely on. That's just an argument.
Okay, thank you for informing me of that. I don't think it's completely irrelevant because it explains. Anyway, the case, well, I don't want to go off topic, but it's important what's going on in my head here, right? And what was going on at each stage, and that impacted that greatly.
It is, and I think you're providing the board all the information they need to resolve this matter. I'm simply saying there's no right to an expungement. That's, you have to request and receive an expungement, and you have not received an expungement yet.
I think there's a right, if it goes the whole 3 years and we didn't request an early expungement, it automatically gets expunged. That's scheduled already.
Okay. But it hasn't happened yet.
Correct, it's not yet happened.
And you have a right to request an exception to the being put on the exclusion list, but that hasn't happened yet, has it?
You talk about the OIG exclusion?
Right.
That's correct. And the administrative law judge recommended that we do that.
Right. I understand that, but
and she indicated she thought it was likely, but hasn't been done yet.
You understand that was the OIG's administrative law judge. That was not an appellate judge in the state court of the states of Mississippi. That was some federal administrative law judge. Okay.
Yes. But a state court wouldn't have any jurisdiction over the OIG, so I'm not sure how that would be relevant.
Well, in this case, the same is true. And as she said in her order, she had no authority to do away with your guilty plea that you made in state court.
Well, there's a nuance here. My older brother is an attorney. And unlike Tom Kirkland, I actually like some attorneys. I asked him about it. And he said, this is a difficult concept. And my older brother, he's a National Merit Scholar. We both were. He's a bright guy. And he said,
Dr. Pelton,
Yes.
I'm going to ask that you refrain from speaking until council has a question,
I'm sorry, I thought he did ask me a question.
not about your brother.
Oh, okay.
Thank you.
This is,
Council, do you have any further questions for?
Just want-
all right,
You haven't been removed from the exclusion list yet, correct? That is correct? Yes or
Correct.
no?
correct.
And no one from the Department of Medicaid or the Attorney General's office or anyone else in state government with authority to do so.
I
has si-
apologize. I'm sorry. I'm trying to take a note, but I missed the first half of your question. I apologize.
No one has signed your request for an exception on behalf of the state of Mississippi, have they?
Not yet.
Tend to the witness.
Council,
You all through? Thank you. Dr. Pelton, where do you live?
I live in Cleveland, Mississippi
How long have you lived in Cleveland?
since 2010. So that would be,
How many years have you practiced medicine in Cleveland?
about 14 and a half.
And tell me what your specialty is.
It's ophthalmology.
Is there any subspecialties that you have, or I don't know about what
Oh.
all ophthalmologists do, but
Yes, sir. I have a fellowship in refractive surgery and in advanced techniques for cataract surgery. I also received additional training at the Washington National Eye Center in my last year of residency. When they ended the fellowship, it gave us basically half a year of fellowship in retina, treating the retina in the second busiest treatment center in the country. So
where did you go to med school?
to University of Michigan.
And your fellowship?
It was, that fellowship was a private fellowship at the Cleveland Eye Clinic in Cleveland, Ohio.
Have you received any other awards, recognition, or accolades professionally?
Oh, yeah, yes, sir, many.
But can you tell the board some of those?
Sure, I can mention some of them. And I brought some in case they're being, well, I'm board certified. And even in the midst of it, I renewed my board certification.
How long have you been board certified?
Well, since when you finish your residency, which I completed in, let's see, 1998, you go through a certification process. There's a written specialty board. So this is American Board of Medical Specialties I'm talking about. And then you do the written part, and then you get oral examinations. And you have to sit in front of 12 different people, and they ask you questions about every subsection of ophthalmology.
So do you know what year that would have been?
Well, count that.
Approximately?
It would have been, well, if I finished in 98, it would have been approximately 2000.
Okay, that didn't mean to interrupt you, but what other, have you received any other awards or
Sure.
accolades professionally?
Well, I always get a lot more CME than is required. I think state of Mississippi requires 20 hours per year, which isn't a lot. And then the American Board of Medical Specialties and American Board of Ophthalmology, they require 30 hours a year in some, but I usually get over 100. I'm in an area where I am practicing comprehensive ophthalmology, and there are a lot of advances being made. In fact, the reason I requested a continuance is I was scheduled to get on a plane to go to a conference, and oh my goodness, I thought I had to bring this.
41091.
I apologize, folks.
That was interesting, though. I don't know what all that was saying.
I have the office phone because right now, because my renewal, we delayed the application to renew the license because we're trying to solve some of these issues before we tendered the renewal application. And so I don't have anybody at the office answering the phone. And so
Can
that
see
phone
it.
rolls over,
Okay.
but there's a different software
that's-
that does that. And
Okay, that's fine.
I promise you, I double checked that. I know.
That's fine. You were talking about CLE or other awards. or
Oh, yes,
accolades
sir.
they receive.
So I hadn't claimed it, but then when I was being investigated, I said, well, I better claim it. So I got from the AMA, I got the Physicians Recognition Award with commendation in continuing medical education, which is their highest certification. I'd always done it. I just had never claimed it, but I thought, well, it won't hurt if I have to say, look, I'm trying my best to study and learn and keep up on things. And in fact, at that meeting, I was talking about these anti-VEGF injections. Well, now there's another pathway, and some of them are trying to combine the two, and that's going to be covered at that meeting. So, which I'll get to see. I'll just probably miss the first day. And then there's this organization, HealthTap, that has, I believe, over 100,000 physicians in there who volunteer time. And then your answers you give help the public. You don't get paid for it. They have something where people can do telemedicine, but I never did that. I never took any money for that. But when this investigation kicked off, I said, well, I'll throw my hat in the ring. They have competitions who gives the best answers as voted on by 10,000 or more other doctors, who gives the most charity care on that website. And in 2013, I came in first in the nation above over 10,000 ophthalmologists that were in that competition. So I got a certificate and a letter from the manager of that program. But that was charity work in addition to what I do in my office. That was online.
Are there others?
Well, I mean, there are. When I was a resident at the Washington Hospital Center, which has the Washington National Eye Center, out of the over 550 doctors they have there, I always got the patient's favorite doctor award. Not only are you rated by other doctors, you're rated by the patients, and I always got the top score from the patients. And they had doctors there that were my heroes. But in the patient's perception, they liked me.
Dr. Pelton, let me ask you this question, kind of out of the way. Where did you grow up?
I grew up in Michigan.
Right.
I grew up in Centerline, Michigan, which is just north of 8 Mile in Detroit. And yes, I do know Eminem, and I do know Kid Rock, and I do.
You just didn't sound like you grew up in Bolivar County, Mississippi to me.
Oh boy, that's something. Well, you always get, y'all ain't from around here. That's now.
I want you to tell the board about this. Before you were excluded, before we had the ZPEC audit, we're going to talk about that in a minute. Can you just kind of give us a short overview of what your practice was like, what type of patients you saw, who you billed for them, what you did for them, that sort of thing?
Yes, sir. It's the Mississippi Delta, so there's an underserved area. You could put 2 other ophthalmologists right next to me, and there'd still be more than enough patients to go around. That doesn't mean that people don't get touchy if they're 50 miles away and some of their patients hear, oh, you love your doctor that much, and they start coming, they get salty. But the fact is that the need is so huge. You could have 3 ophthalmologists just in Bolivar County, and there's nobody in Sunflower County. They come to me. And in Washington County to the south, there's an older ophthalmologist pushing 80 or has gone over 80, and his practice is restricted. And then to the north, thank God, there's a very good ophthalmologist, but he's over 60 and his partner is over 80. So it's an extremely underserved area.
You get paid by all your patients?
Oh, I'm sorry. That's just funny to anybody who's been in the Delta. No, it's a very poor area. And I knew that before I went there. A lot of the patients don't even have any insurance. And if they have a retina problem and no insurance, no retina group in the state, no retina doctors will touch them other than me. Because
Do you ever sue a patient to get money from them to get paid?
no, sir. I don't get paid all the time. I've never turned a patient over to collections. And I've been advised by other doctors and business managers that's just financial suicide. And I said, well, I didn't come down here to make money. I worked really hard where I was before I came, and I knew what I was getting into. And that's just a matter of my personal faith. I take it pretty seriously. The parable about the man who was forgiven his huge debts by his king and turned around and grabbed somebody by his throat and said, pay me what you owe. And that was an example in our gospel saying, hey, don't be like that. Say, we're blessed. I live modestly because I want my children to see that. But I'm not trying to squeeze money. Everybody, I drove up here in my 2013 Ford F-150 pickup truck. I live in a house that's less than 2,000 square feet by choice. I mean, I could afford a newer truck. I could afford a bigger house, but not from working in the Delta, but from work that I did before. I knew that it was going to be financially challenging. Our county is over 70% African American. It's rural. It's poor. We have other minorities there too, and they were very underserved. Some things have gotten better. Care in diabetes has gotten better. Our internal medicine and family practice doctors are a lot more effective than they used to be. It was extremely common when I got there. Every week, every month, I was diagnosing people with diabetes and then sending them to family practice or internal because of they were far enough along that they had ocular manifestations. But this is improving a lot. And so as the primary care treatment improves, the ophthalmology cases aren't as severe as they were. But when I say that, they're still very severe. There's a huge need. It's still very severe. It's just progress is being made. So we had a mix between Medicare and Medicaid and Medicare HMOs and private pay patients and Blue Cross and United Healthcare. And
This question, this matter all started with Z-PIC audit, and you've already told us about Z-PIC audits. Had you ever had a Z-PIC audit before?
no, I had not.
Had any kind of an audit?
No, well, okay. All of the Medicare HMOs do a paper audit. They, I think they're required to sample enough practices. And if you're busy, they're going to request charge more. Now, I never had to pay money back on those. You get the audit and I passed everything. In fact, as this was going down, I was getting audited by everybody. Blue Cross Blue Shield, they passed me. United Healthcare, they passed me. And that's hard to do because they'll just deny anything.
Medicare sent you a letter saying that you owed back $272,000 on the Z-PIC audit.
I think it was 300 or something.
300 something. Okay. You paid that?
Yeah, well, then they turned it over to Novitas, and those buggers wouldn't send me one letter. They sent me dozens and dozens and dozens. That every patient that had received such treatment, they said, well, we don't, like that, because you used that modifier and you gave the treatment in an expedited fashion, we want all that money back.
They sent you a letter by claim by patient.
Patient by patient by patient, or a couple patients.
But you paid all that money back.
I did. I paid them all within 30 days of receiving.
And Medicaid came in and said they wanted, and they didn't prosecute you or anything. Medicare didn't, right?
No, in fact, the opposite. They said, well, what our finding is we want money, and then this is the Z-PIC audit. We want money, and then what we say is you're going to have education. And I called them up and I said, okay, what education? And they said, well, look at the last page. I said, yeah. They said, well, we don't agree with you using modifier -79 in this way, in this instance. I said, okay. And they said, well, that's it. I said, what? Your education, what? Just don't use that modifier in that way anymore.
Did Medicaid
okay.
send you a letter saying they wanted some money back?
Did Medicaid?
Medicaid.
No, they did not. I settled with Medicare, but some of these people have Medicare and Medicaid. And so Medicaid is tied to whatever Medicare decides. If Medicare pays, Medicaid has to pay. If Medicare denies or requests repayment, then Medicaid has to request repayment. And if Medicare says this global period has changed from 90 days to 10 days, and although we had no guidance, we're creating it, Medicaid also has to follow that, even though they didn't.
But did you
at least
pay
not for me.
Medicaid money back?
Yes, eventually. I contacted them and said, hey, I had to repay money to Medicare. I think I owe you money, and here's what I calculated it out to be. They said, do not pay, we'll let you know. And you may have to pay 4 times that if we go to a criminal session. And,
Which they did.
well, they filed indictments, but they neglected to prosecute. They held on to it and they filed secret indictments coincident with the launch of the campaign for governor of the then Attorney General Jim Hood. And they attempted to deny me bail. I picked up the attempted to deny bail. Now it was granted bail, but I had to pay, whereas every other doctor always got released on their own recognizance. I was treated differently than other people. And like you said, y'all ain't from around here. So
I hand him a list of the exhibits, my exhibits to refer to.
So, but when my lawyer, Derek Simmons, was contacted by, well, one administration declined to prosecute the case, then the next one declined, and then they hired an outside third party, outside independent contractor, and he contacted my attorney and offered a plea deal, and they negotiated repayments. So it wasn't, there was no criminal finding of it, but it was just repayment.
If you had known that this non-adjudication plea was going to result in an exclusion from Medicare, and Medicaid, would you have agreed to the non-adjudication order?
No, absolutely not. The only reason I accepted to go this route, my lawyer is saying, well, hey, I got you, trust me. If you pay this money and sign this thing, then this attempt to play, then you won't have to appear in front of the medical board. Your license will never be at risk. You won't have any problems. You go right back to practice, and this is going to resolve everything. And he said that in his experience, he was able to get things expunged rather more quickly.
Take a look at what is Exhibit I in the book I've handed you of exhibits. Do you recognize this document?
Yes, sir.
What is it?
This is, as explained to me by attorneys, this is not a guilty plea. This is a petition to enter a plea of guilty, which I had attempted to explain before. And it was explained to me, and I'm not an attorney. The attorney said this is rather nuanced, and not all attorneys get it if they don't practice it in this area. But it doesn't become a guilty plea. It's not a plea of guilty until the judge accepts it. This is a petition. You're saying, and this is just the technical aspect of the non-adjudication pathway. They say you have to attempt to enter a plea. The judge doesn't accept it. They set it aside. Now, if you would get in trouble during, if you would not fulfill the terms of the probation, or you would get in trouble, then it would automatically become a guilty plea. You don't get to appeal it. You don't get a hearing. They just move straight to sentencing.
Take a look at the next to last paragraph. There's the language in next to last paragraph says, I provided medical care, billed the division Medicaid accordingly. And then it says this, but it is disputed whether the billing was proper within the 90-day global period. What does that mean to you, and why is it in there?
Yep, it's in there. Initially, the offer came from the third-party representative from the AG's office. Hey, we want him to sign and plead to one count, and we won't object to a non-adjudication, and we'll work out some repayment. And initially they were asking me to say, oh, this is true, that that one of the indictments was true. Well, none of them were true. I hadn't committed any crimes. And yes, I had to repay money, but I provided that care in good faith, expecting to get paid, and I got paid for care that I did that the patients needed. Now, that's not a crime, and I thought that the billing was proper, and I still think the billing was proper, because everybody has always gotten paid for every surgical stage of a stage procedure. You just don't, and if it's a global period, you just don't get paid for the subsequent medical visits that don't include.
What are the last portion of that language, but it is disputed whether the billing was proper, mean to you?
Okay, my attorney, Derek Simmons, I objected, and I said, look, I can't say that I billed them fraudulently because I didn't, and I never tried to, and I never intended. I thought I was doing the right thing. He said, okay, let me see if I can resolve this. And so he rewrote it to say, okay, I provided the care and billed accordingly, meaning to my mind, I thought it was accordingly, but we're disputing whether the billing was proper within the 90-day global period. Now, it's interesting because by the time the Attorney General's office filed their indictments, they listed 90 days, 90 days, 90 days, but it had been 10 days for almost 2 years. And you all probably know, just if you've watched TV or whatever, but anytime there's a change, especially a change that happened because of you, when Medicare changed, it automatically changed for Medicaid, and Medicaid already knew and was supposed to know, and I had instructed my attorney to make sure they know, hey, it's 10 days. So people doing right now, today, people are doing what I did, and it's fine. And there's no problem.
Counsel, for the board asked you the question about or had read to you a lot out of the transcript of some, I guess it was a court proceeding or questioning between your attorney and Judge Webster, and about whether or not you were pleading or doing that. Did you understand that you were pleading guilty to the charges, or did you understand that the judge refused to accept any type of a plea?
Okay. What my attorney Simmons told me is that because he had worked out a deal with the Attorney General's office, Division of Medicaid, that that it would be highly unusual for the judge not to accept it. But if the judge decided he's going to accept a plea, that what Simmons said is that could be undone and then we'd go to court. Because I had said from the beginning, let's just go to court. We've got proof on everything. And he said, well, you could do that, but he said, well, all it takes is for one juror to be jealous of you for any reason, thinks your doctor, you got more money, or for whatever, somebody gets stuck. And if they give even one, or the prosecuting attorney is extremely charming or something, they looks like they threw hard, did well, worked hard on this. Let's just throw them a bone. One thing, then even though he said it's highly unlikely you go to jail or anything for something, you would lose your license.
Did the judge accept the plea?
The judge did not. And this thing says petition to enter a plea of guilty. And what he said is it doesn't become a guilty plea unless the judge accepts it. It's just a request. Your Honor, may I tender a plea of guilty? And the only reason you have to do that is because that's the technical aspect of the pathway of non-adjudication.
Okay. I have one other area I want to talk to you about, and I want you to look at Exhibit C, which is the OIG opinion. And I want to start at the bottom of page 5 of that opinion. And I want to read to you this portion here that the Office of Inspector General Administrative Law just said. Lastly, petitioner essentially argues in his RFH that the underlying Medicaid fraud charge from which this proceeding derives was meritless for a number of reasons. Mississippi did not have a local coverage determination regarding the use of CPT codes at issue during the relevant time period, and there were no Medicaid requirements at that time. As such, petitioner did not and could not have had knowledge that his claims were false. And I want to ask you, what do you understand that means?
That language is important for Medicare because it's what it's saying is there was no local coverage determination. You did the best you could from the coding handbooks. You asked questions. You asked everybody that you could ask. They all said, yeah, it's okay to do it that way. You're doing fine. And then someone said, no, it's not. You have to repay money. But there's no way that I could have known to do it any differently, because all I was doing was doing the work that was necessary and trying to get paid for what I actually did.
Well, I want to ask you about that. The administrative law judge at the bottom of page 5 of Exhibit C goes on to say the same issue was highlighted during a zone program integrity contractor audit, that's CPIC audit. of Medicare claims and was determined to be a billing error as opposed to fraud, and petitioner paid back the associated funds. That's true, isn't it?
That is true.
Okay. Then she says the AMA guidance at this time provided with respect to the CPT coded issue that the treatment of a global period is determined by the physician and varies depending on the patient diagnosis and often the area to be treated. You see that?
Yes, sir. That's true. That is what the
Okay.
AMA coding handbook says. And when there's no LCD, there's no coverage for that. And you can't get a definitive answer from Medicare, and Medicaid says you're doing okay. You've got to go all the way back to the AMA coding handbook. And we looked at it, and it said specifically in the AMA coding handbook, and that's what the judge is quoting from, that it's up to that the treatment schedule of the stage treatments is determined by the physician, and it varies depending on the patient diagnosis and area to be treated. And this is why I said to these, I said, look, you took money back from me. There was no precedent. There's no guidance. You've created a precedent. And with that, tens of thousands of people across the US are going to go blind now. You keep this at 90 days and you do this. It's, you know, I might be the only person you've taken money back from, but now everybody's going to be guilty of it and or not guilty of attempt to commit fraud, but just of making this error. Whatever, or maybe they have better billers, and maybe they have a better modifier or a Medicare carrier like Cohabas that says, yeah, that's correct, because it varies. It's not even the same across. There was no national standard. Now Medicare has made a national standard. They said it's 10 days. We don't want these patients going blind, so we've made it 10 days.
So do I understand that at the time that you were under the impression that based on the American Medical Association guidelines, the treatment for these patients and the frequency of this procedure was left up to the physician based on the patient and the patient's needs?
Yes, that's correct. And it still is. That's 100% correct.
And I want to call your attention to one more line of what the OIG said. Following that paragraph on page 6, the first full paragraph, the OIG says, once again, despite the facts underlying petitioner's conviction appear to be on the current record to amount to nothing more than a billing error at best. Do you understand that your conviction or that the exclusion by the OIG is based on nothing more than a billing error at best?
Jack, the document speaks for itself. It's been covered about 10 times already. It's repetitive. And I moved to for the question.
No, that's fine. I agree with him. I think it's quite clear. It's just that I'm a lawyer and we just want to make things clear and clearer and clearer on that. Doctor, I don't have any additional questions for you, unless there's some matter that you think the board needs to hear that they haven't already heard.
Just said, this is the only time in my life that I've ever been in trouble. I grew up in a very rough neighborhood, but I was considered the goody two shoes of the neighborhood. In fact, I was always the guy that got other kids out of trouble and avoided fights and whatnot. I worked very hard. I tried to set an example for my children who are coming of age to really notice what their parents do, to move to an underserved area and give my life to service. When one of my patients died, who was my dear brother in Christ, I went to his funeral and I was shocked to see that I was the only white person at that funeral, because this man he was friends with everybody and he was a preacher. And shortly before he passed unexpectedly, he was talking to me about completing divinity studies and getting ordained. And I realized that I needed to do that. And I did that. And I preach in black churches and white churches. And because of that, when the disaster strikes, I'm able to get help from, I got Baptists and Methodists to work together. That hadn't happened since Prohibition.
I don't have any more questions. Thank you.
Thank you. Counsel, prior to your redirect, the chair has informed me that she would like to break for lunch. if that is amenable.
Well, I would like to state for the record that I will refrain from cross-examining the doctor because I do not believe it would be helpful to the board.
Okay. If that's the case, we will reconvene with board questions after lunch. At such time, we will be back here at 1:15.
We will provide lunch for the defense. And if y'all would like to go first, you come back here into our conference room. And then we have a break room over here, which will be private, and you can talk amongst yourselves without having to worry about us.
I appreciate that, but I never cut first in line to eat.
Well, it's the only, logistically, it's the only way we can do it.
All right, Michigan, we're doing Southern hospitality. You've been here long enough now.
Also, for the record, I'd like to remind board members to refrain from discussing this matter during lunch. Thank you.
They can get my lawyer. That's fine. We got plenty. They're going to school, yeah.
Okay, that's fine. We got plenty.
Okay.
They can come get lunch too.
Y'all want to come on?
So much for your help. Oh my goodness, that was embarrassing. At some point in their life.
My daughter. I know more than I want.
Oh, no, kick Tom's briefcase.
Go right back over there.
You just leave your coat here.
Yeah.
I don't think anyone's gonna steal it. The camera's on.
We had, well, I guess I'll turn this over to Madam Hearing Officer.
Okay, at this time, I would like to open the floor to the board members for any questions that you have for Dr. Pelton.
Dr. Roth.
Randy Roth from CMO at Singing River in Pasco, Mississippi. Just one or two questions. Have you had any adverse actions taken against your license not previously, in Cleveland prior to your move to Mississippi?
Oh, no, sir.
Any active investigations of peer review activity?
Now?
No, prior to coming to Mississippi.
No, that's my knowledge.
Okay. Were
Can you
ever?
please turn on your mic?
I'm
Sorry,
sorry.
gentlemen.
yes,
You got
close.
yours on.
I'm on. Okay, thank you.
One on the right. Yeah, there you go.
And I guess the last question is, at no time in any of this events that were happening, were you ever aware of any possibility of fraudulent billing activity?
That's correct. I thought it was being done correctly.
Thank you.
I have a couple of questions. So, would you say that the billing so first of all, where did you learn to bill?
Good question. Because you don't learn it in medical school and you don't learn it in residency. And so I worked, and still don't know how to bill, but for coding, when I was a young doctor, first in my fellowship and then as an employee in a practice, they had a sheet, coding sheet, and in order to assist their coders and billers, they required the doctor to circle what you did, level 4 visit and what the diagnoses were, right? And whether not every practice has a doctor do that back then, and those were ICD-9 codes. That's how long ago it was. But every practice in America had a sheet like that up on the corkboard at the desk of the biller or coder, and that was actually mischaracterized against me, presented by the AG's office as if that were a cheat sheet, a criminal smoking gun, when all it was is it just has diagnosis codes and CPT codes and modifiers on it and the names, but those names are scary to non-medical people, the diagnosis, and they're like, oh, that looks complicated, but that's all it was. So I got that coding knowledge there. Then we have classes at the ASCRS, the American Society of Cataract and Refractive Surgery, and they run coincident to that. They have classes also for your medical staff, your assistant staff, to learn. And I attended classes there, and then you ask the questions that you have of the people that are teaching the classes. And so through that experience, first through having to do the coding, and then if anything's coded incorrectly, then the coders come back and tell you, hey, doc, you can't do it this way. We have to do it this way. You learn that through experience. But then I took classes, not every year, but several years, especially if the class looked like it might pertain to my practice, when I would go to ASCRS and sometimes the American Academy of Ophthalmology meeting. At the meetings, I would take classes, and then they have guides, and then they have something called ASOA, American Society of Ophthalmic Ancillary Staff or Assistants, and you can call them and ask them questions. So many per year, and then you have to start paying for them. But and so that's what we would do.
So, and these charges that were in question, that were brought up specifically during the investigation, those were charges that you submitted. The coding was coding that you submitted yourself, like that with the use of the modifier. Either you instructed somebody to drop those codes for you, or you actually did that yourself.
Well, I didn't actually do it myself.
Okay.
My office staff did. I was aware they're doing it that way, but my instructions were, look, let's make sure before we do it that way. Sure, I want to get paid for the work I did, but we have to do everything correctly. And that's why I consulted as many people as possible. And there just was no local coverage determination. There just was no guidance at all. It all went back to only the AMA coding handbook that said the length, the timing of the stages of each stage is completely up to the treating physician. And that's all I had to go off of.
And so at the time, were you aware that of the global, as proceduralists, many of us are familiar with the concept of a global fee. Were you aware that the procedures that you were doing were considered part of a global fee? Was that a question at all, or was that something that you fully understood?
Well, my understanding of it then and now is that when you get a global fee, you get paid for the procedure you did. And then during that global period, even though you're required to submit a bill for all the care, surgical or medical, that the medical part won't get paid. Just don't expect, it's not going to get paid. That's included in the global payment. But if you do a subsequent surgery that's necessary, then you do get paid. But if it's your fault because you messed up and you got to go back to the OR or something, you get paid a reduced amount. So they have different codes, different modifiers for that. But mine in question weren't because of a mess up or anything. It was just planned stage treatments and trying to expedite the care of the patient, which today would be perfectly fine, not even questioned, because it's 10 days now. It's not 90 days. So this period, but there is clear guidance now. And that guidance actually was written by one of the consulting firms I hired to look into this for me. They said there just is no guidance. And so they helped lobby Medicare. Look, people are going to go blind. There's a problem now. This has to be fixed. You've got to give guidance. And so they reduced the global period from 90 days to 10 days and said, don't bill us more than once in a 10-day period. Well, that's not necessary because 10 days is perfectly reasonable.
Yeah, I was just looking through the documentation that in your exhibits, and I think some of the things that were called into question was related to the use of that 79 modifier. I think you had made reference to, and I think at least the way that I interpreted what was written is that the difference of whether or not it's something that's related or unrelated, because that's something that's an important distinction for them to make a determination about in the concept of determining reimbursement. And so for things that are related, they would not be reimbursable under that global fee. The modifier would be the thing that would trigger them to say that this is something that's not related and therefore would be a reason to reimburse. And I don't know that that's different than what you're saying, but it's your position was that you perceive those as being different and distinctive, and that's why the modifier was utilized. Is that what you're saying?
Yes, ma'am. Those are
Okay.
Each stage of a stage procedure is different and distinct you're not treating that same area again. You're going to a new area to treat it. It is different. It is distinct. And that was my understanding. It's just that and COHABA agreed with that. And Medicaid used to agree with that. They agreed to it with it twice. It's just that after Novitas said no, and then the ZPIC unit came in, that guy said, okay, well, we don't agree. And we're going retroactive because Novitas has said, well, this is how we do our claims. We don't go back into COHABA claims, but apparently the ZPIC can. And
So one other thing, and this one might be a little bit of a challenge for you. Your contention here and your position has been that you didn't do anything wrong. Is there a lesson to be learned from this experience at all?
yes, ma'am, a whole bunch of lessons. Okay.
Give me a top 3.
Okay, if you're in private practice and there's billing, even if you've asked questions, you need to do more than that. You need to hire a consulting firm like I did after the fact to come in and go through your billing and do audits and shadow audits, not just rely on the audits that come from Blue Cross and United Healthcare and everybody else where they request charts and they say, okay, you're fine, you're doing well, which I mistakenly thought that I was doing well. And just because they say it's okay, it's necessary to cover your, behind. The only education I got on that from the ZPIC was just don't use modifier 79 like that anymore. That's was my only education. And there wouldn't be a lot more to do, but there do exist national firms that will audit your practice and come in to either confirm it or find something that they think isn't best practice, and you get the chance to change it to best practice. So that's the top lesson. A lot of the other things, you always think you know what's most important to you. And when you're in adversity, it brings a person to your knees. And even though I didn't do the things that I got accused of, doesn't mean I'm a perfect person, and you do deeply re-examine your life and try to correct and do what you can. Also, life's not always fair, right? And even though I didn't get paid by Medicaid anymore, I kept seeing those Medicaid patients for, up until the time when it was time for license renewal, when we were trying to sort some things out. And I apologize for that license renewal for being late, but we were trying to clear up some of these issues before I submitted that license renewal. But I was still seeing those patients don't have anywhere else to go, and they can't get transportation to go somewhere else. So even though I wasn't going to get paid, I still saw them. I didn't ask them for money. I still saw them. I'm committed to that mission. You get deeply ingrained to, what is your mission on that. But it's a strain to hold up. The worst thing that happened is after 7 years of this, my wife fearing that she felt we weren't being treated fairly, and she feared for more unfair treatment, and she had a breakdown, and she was desperate to get out of the Delta. She went out to Arizona with my daughter, and it's just broken my heart, and it's a bigger loss than, I didn't want to pay back money, and especially didn't want to pay back money and then have Medicare say, just kidding. You were right all along. We changed it to what you said, but we're not giving the money back. Ouch, that stings. But I'm still here. I'm still working if I can. I still have two hands. I still have my senses and the ability to help people. I'm grateful for that. I got a roof over my head. I'm grateful for all of that. And so you really learn to focus more on what's important. And yes, I've learned more and more about billing. And yes, when I go to the meetings, I do try to attend these classes and learn, because it's, as soon as you learn it and you think you know it, they change the rules. And then you've got to go learn and see what changed. And some of these emails that I used to toss out, hey, billing, coding updates, I pay more attention to that instead of, but the top thing is don't just think because you give all the resources to your billing staff, they're doing it right, or they're going to keep doing it right, because they could make a mistake and you don't know on the day-to-day operations. Even your internal audits might not catch it. Get an external auditor to come into your practice and help you out, even if it's just letting them randomly select the charts and you send them the charts and you give them a representative sample of what you're doing.
And I think that you make a really good point. We sign up as lifelong learners, and we use that term quite frequently, and it's more than just CME. But I think it's also important to remember that, the people that we surround ourselves in the healthcare environment are also people who are extensions of us. They are viewed that way.
Yes.
Your biller and your coder, they don't lose their license, or their license is not in jeopardy for those mistakes, but sometimes those things do end up having negative consequences on us because those people are acting on our behalf. Those are all the questions that I have for now. Thank you.
Okay. Any other board members have questions? Okay.
Attorneys are also lifelong learners, so I will waive any further questions.
Any more questions?
Dr. Pelton, you may be excused. Any other witnesses at this time?
No, complaint counsel rests.
Okay.
No more witnesses. Thank you.
At this time, I would like to hear closing statements.
Complaint counsel waives any closing statement.
Okay. Counsel.
I'm sorry, I just can't not have any more questions. I wish I could. It's just not part of me. I just want to say one thing to y'all about this. I'm not going to talk about whether he had a guilty plea or not. I'm sure that's even relevant. We are where we are on all of this. And the only thing I would just say to the board was, under 73-25-121, there are conditions based on exclusion of what y'all can do as far as issuing his license, whether it's probationary or rescinded or whatever you do. And I was just gonna ask y'all at this time, personally, I very much believe this, that there's nothing that this board needs to do with regard to this man's license concerning the practice that what little he still has left. He is an excellent clinician. He's not billing for fraud, not making fraud. I think he probably is a better coder today than he was. And I just don't think he needs any more piling on at this stage. We will file the waiver, I assure you of that, and we will get that. This matter is going to be expunged off of his record, and we're going to get that. So I would just, to me, think that, he's in the position that he's in with Medicare, and by golly, they're watching him, and he isn't going to be billing anything that he can't do. And other than that, I think he makes a big difference in the Delta. I think he's a meaningful physician that meets a need. So I would just like to say, I would like him to move on and let us do these things that we need to do as lawyers to get him back in the full practice of medicine.
Thank you. At this time, this concludes the hearing in this matter. I will turn it over to Madam President.
All right. At this time, I'm ready to entertain a motion.
Make a motion to close the hearing and consider going into executive session.
It's been moved and properly seconded that we close the meeting to consider whether to go into executive session on this matter. Thank you, Dr. Kennard. Any discussion? All those in favor? Aye. Any opposed? All right, thank you. We are now back in open session and Dr. Lippincott will give the board's decision from executive session.
In the matter of, in the case of Harold Lee Pelton, MD, the board's decision is to dismiss the charges. That's all.
You're welcome. And we will continue on to the last matter on today's agenda. Which is the show cause hearing in the case of Miguel Antonatos, an applicant from Chicago, Illinois.
Madam President and Madam Hearing Officer, I believe it's Dr. Antonatos. I don't know if if I'm pronouncing that right, but I'm hoping he'll correct my pronunciation if it's wrong. But I want to make sure that he can hear me and that we can hear him.
Yeah, I can hear.
Could you speak up a little, sir?
Yeah, I can hear you. Can you hear me?
It's a little
Yes, we
quiet.
can.
But if you could speak up, it would be helpful.
Yes, I will.
Dr. Antonatos, am I correct that you are appearing pro se? You do not have a lawyer representing you?
Yeah, I'm processing.
Okay, well, then I believe our hearing officer may have some questions she wants to ask you.
Hey, good afternoon. My name is Alexis Morris. I will serve as the hearing officer in this matter. Can you hear me?
Yes, I can hear you clear.
Great. Okay. Now, you do understand that you have the right to an attorney for these proceedings, correct?
Yes, correct.
You also understand that you have the right to call any witnesses to testify on your behalf.
Yes, correct.
You further understand that you have the right to have subpoenas issued by the board on your behalf.
Yes,
Okay. And notwithstanding the same, you wish to proceed in this matter without counsel today?
yes.
Okay, thank you.
All right, and again, Dr. Antonatos and I have not had an opportunity to speak, but I would like to see if we can do some housekeeping up front. And Dr. Antonatos, I believe that my paralegal sent you a document. We've produced a lot of documents to you in response to your discovery request, correct?
Yes, correct.
And then she sent you in the last couple of days a much smaller group of documents that she said were going to be our exhibits. Do you recall that?
Yeah, yes.
And so I will list them out for the record, but for each one, I'm going to ask whether you have any objections to that being admitted as an exhibit to evidence. And that way, I think we can move this along quicker.
Okay.
Okay, the first
Counsel,
document.
before you proceed, if we could have Dr. sworn in,
Yes,
it'd be
absolutely. I'm
great.
sorry.
Madam Hearing Officer, thank you. Court reporter.
If you'll raise your right hand. Doctor. Do you solemnly swear or affirm the testimony you're about to give in this cause is the truth, the whole truth, and nothing but the truth to help you God?
I do.
Okay, Dr. Antonatos, do you have a copy of the documents, the file that we sent you available?
Yeah, I received them.
Okay. Well, if you would, I'm going to offer first, the affidavit in connection with the show cause hearing. That is got, let me back up. We have added identification numbers in the bottom right-hand corner of the documents that begins MSBML, and then there's a sequential number. We call those Bates numbers, and that's so we can point to a specific page. And so this document, the affidavit of Krista Garnett, is begins on page 1 and goes through page 3. Do you have any objection to that?
No, no objections.
Okay, and then pages 4 and 5, or the order to show cause, which was served on you. Do you have any objection to that?
No objections.
Okay. Pages 6 and 7 are some emails between you and Ms. Garnett, where you're confirming that you were accepting electronic service. Do you have any objection to admission of that?
No objections.
And I apologize, but for the record, we have to formally go through these. Pages 8 and 9 is a complaint report that we received here at the board. Do you have any objection to that?
No objections.
Okay. And I think there's multiple copies of this next document in here, but I want to make sure that I identify one of them. Starting on page 10 and going through page 25, 10 through 25, is a copy of an order of the State of Washington Medical Commission that's entitled Stipulated Findings of Fact, Conclusions of Law, and Agreed Order. Do you have any objection to the admission of that document?
No objections.
Okay. Starting on page 313 and going through page 324, that's a statement of charges that was brought against you in the state of Washington. Do you have any objection to that?
No objections.
Okay. Starting on page 405 and going through page 414, that is a printout from our computer system of your application for a permanent license. Do you object to that?
No objections.
Okay. On page 135 and 136 is a copy of a letter from Dr. Cleveland to you dated October 10th, 2024, denying your application. Do you have any objection to the admission of that?
No objections.
Pages 417 through 419 are emails between you and Investigator Garnett concerning whether your appearance by Zoom and that you would be out of the country, et cetera. Do you have any objections to the admission of that?
No objections.
Okay.
Yeah,
All right.
no objections.
Okay, thank you. Okay. Beginning on 420, it's a declaration of service by mail from the State of Washington Medical Commission. And attached to that, beginning on 421, is a notice of decision on application. And I believe you produced this to us. And there is a decision. This is a decision which is stating that you must sign and date an enclosed proposed agreement to practice under conditions. And then beginning on 425, there's actually the document that you were asked. I'm sorry, that's a preliminary document that the file goes on. Beginning on 429 is a copy of the actual agreement to practice under conditions that goes through page 444, 445. Now, do you have any objection to that?
No objections.
Okay, and I do wish to ask you a question about that. The copy that I have is unsigned. Is there a signed version of that, or is that unsigned
No,
the only one? The unsigned is the only one?
yes, I never signed it.
Okay. Then on page 446 through 449, that's a copy of this board's regulations, part 2635, chapter 5, practice of telemedicine. You have a copy of that. Do you have any objection?
Yes, no objections.
And then last, beginning on page 450 is a cover letter, and running through page 466 is another copy of the agreed order from Washington, the stipulated findings of fact, conclusions of law, and agreed order. This one was printed yesterday. So as far as I understand it, I want to confirm first, do you have any objections?
No objections.
And it's my understanding that's the latest document concerning your licensure from the state of Washington. Is that correct?
Yeah, I believe so.
Okay. Those are the exhibits I plan to introduce. Dr. Antonatos has produced a lot of documents, and so I would, unless he can tell me now what he wants to introduce, I would reserve my objections at the time to see what he plans to use, what he plans to introduce, and for what purpose.
Okay. At this time, we will admit the board's exhibits into the record.
May I make an opening statement?
Absolutely.
Dr. Antonatos was originally held a compact license here in Mississippi. He was licensed under the compact, and he was licensed in numerous states under the compact, including the state of Washington. Now, in 2023, August of 2023, Dr. Antonatos signed an agreed order with the state of Washington in which admitting certain facts concerning his practice of telemedicine and agreeing to certain consequences. And the primary provision of, or the primary accusations in the order were that Dr. Antonatos was practicing telemedicine and had prescribed medications. It happened to be ivermectin, but it had prescribed medications through telemedicine without creating a bona fide physician-patient relationship, and because he did it only through questionnaire and text and did not have any real-time audio or visual interaction with the patient. Dr. Antonatos agreed to that order. He agreed and stipulated to the facts. There are 4 patients listed in the order, which I will ask him about. In each case, the Washington medical condition found, and Dr. Antonatos agreed that he had not created a proper physician-patient relationship. And he agreed in the order that he would not practice in Washington or prescribe medications without first creating a bona fide physician-patient relationship. That disciplinary action made Dr. Antonatos no longer eligible for compact licensure, no longer eligible to receive expedited renewals from the states. So Dr. Antonatos had to apply for permanent licenses in other states, including Mississippi, because his compact license, he could not renew it as a compact license. Dr. Antonatos applied for a permanent license in Mississippi, and the executive director denied it based on the Washington action. Okay. And it is the the underlying basis of that disciplinary action that concerned the executive director because of the fact that the way that order specifies that Dr. Antonatos practiced telemedicine would also violate Mississippi's regulations for the practice of telemedicine, in that there was no, excuse me, audiovisual interaction with the patient. Dr. Antonatos elected to appeal to this board, appealed the executive director's decision to deny his application for permanent license. And so we're here to allow the board to make a decision as to whether or not the executive director should be upheld or whether Dr. Antonatos should be given a license, and if so, under what terms.
Thank you. At this time, Doctor, you may proceed with any opening statements.
Yeah, first of all, can I mention the exhibits I would like to present? I sent a series of documents that actually show critical evidence that the Washington Commission ignored or dismissed.
Yes, counsel actually reserved his objection to allow those to be admitted. And he would let you admit those. I guess you reserved your objections, so you can admit those as you present your case today, if you would so choose. If you would like to admit them now, I can allow you to do that. However, counsel has said he reserved his objections.
I believe I could object at this time.
Okay, that's fine. Let's proceed with the exhibit introductions.
Yeah, I would like to introduce the exhibit named Medici Incomplete Records, and the demand letter from the attorney Anjali Dooley sent to Medici Company.
Okay, we are gathering that information, so give counsel 1 second.
Also, I would like to include all the letters I received for all the other state boards where I'm licensed, dismissing the Washington Commission disciplinary actions.
All right. I object to the admission of any documents related to Medici, which is a company, because it appears to be Dr. Antonatos' intent to use these documents to challenge or undercut or make an improper collateral attack on the validity of the State of Washington Medical Commission order. That sort of collateral attack is improper. Further, after reviewing these documents, those documents were available to the Washington Medical Commission before entry of the August 2023 order. Therefore, I believe these are being offered for a prohibited purpose. They're improper, and I object.
Okay, so as of now, it appears the initial request from Doctor was to admit all of the dismissals from the other states. Is that correct? Was that your first request? Any objection to the letters of dismissal from the other states?
I have no objection to the dismissals from other states.
Okay.
I apologize for getting ahead of things.
No problem. I'm just making sure I'm following him for the record as well. And so I have a 2023-606 dismissal letter that includes an Alabama dismissal letter, that includes a Georgia letter of dismissal, that includes an Iowa letter closing investigation. I have a Michigan letter amended and proposed to respondent that looks like a Nebraska letter, an Oklahoma dismissal letter, and a Utah letter of concern. Any objections to those being admitted into the record at this time?
Are those documents bearing our Bates numbers?
Yes, those documents are included in the board's shared file under Antonatos. It says produced by licensee.
And he has produced additional documents. These documents, which we were not planning to offer as exhibits, constitutes his licensure file.
Okay.
This is everything And he asked for it in discovery. We produced it. We have no objection to any document from the licensure file being introduced.
Thank you. And Madam President, informed me that South Dakota is also included in that list of letters as well. The next item that I have is the Medici demand letter. Am I pronouncing that correct? Medici?
Yes.
Okay. Any objection to that letter, counsel?
Yes, and I object to that letter, and I believe that Dr. Antonatos may be planning to offer other documents related to this, including a letter from his attorney in Washington to the Washington Medical Commission raising this issue about Medici prior to the date of the entry of the order. If he is offering this to allege that there was some sort of impropriety or that the Washington order is invalid, then yes, I object, depending on his purpose.
Any response to that, doctor?
Well, the Washington Medical Commission did not complete the investigation. They rely on incomplete medical records, and this was a speculation, mostly the disciplinary action.
Okay. In terms of the letter, I'm going to deny your request to allow this documentation to be entered as an exhibit at this time. And in the future, if you would like to refer to anything other than the exhibits that have already been introduced, please let me know so that I could get counsel's objection if there is one. And so for now, for purposes of a little bit of expediting this process, we're going to move forward with those letters of dismissal from the states. And I have denied the request to enter the Medici demand letter. Any other documentation that you refer to, we will take that matter up as we go along, okay?
Okay.
I will entertain opening statements at this time. So you may proceed.
Okay, so first of all, good afternoon, members of the board, and thank you for the opportunity to address these allegations. My name is Dr. Miguel Antonatos. I'm a board-certified internal medicine physician with multiple state license, including California, Florida, Illinois, Idaho, Iowa, South Dakota, Michigan, New Jersey, New York, South Carolina, New Hampshire, Nevada, Arizona, Maryland. I'm the owner of the company Text2MD. So I want to provide a summary of my background. I completed internal medicine residency in Morristown Memorial Hospital in New Jersey in 2011. After completing my residency, I worked as hospital medicine physician in underserved areas in New Jersey, South Carolina, and Illinois. I worked hospital medicine physician until June 2021. My last employer was Northwestern Medical Group in Chicago, Illinois, where I left voluntary with no disciplinary actions or concerns for my patient care or quality of care or any other health system I ever worked. I started the company Text2MD back in November 2018 after my wife passed away from a tragic accident on September 2018. And it was left me with a 4-year-old son to rise, and hospital assignment in Northwestern was challenging to continue due to the sudden loss of my wife and no family support in the area. I asked my employer back then in the Northwestern to have a leave from the hospital to focus on my child, as it required more of my presence. And I started a telemedicine company, which was intended to help patients without medical insurance and patients in underserved areas. Then I was able to return to hospital assignments in Northwestern in 2019, around June. When the pandemic hit Illinois and Chicago area in March 2020, I was assigned to COVID units, treating mostly Hispanic patients or Spanish-speaking patients, as I was the only hospital who speaks Spanish during that time. In the hospital, we used non-FDA-approved medication like hydroxychloroquine, and later remdesivir under EUA. The mortality rate was high and was concerned for my health and my child. During that time, patients concerned for COVID or afflicted with COVID started to request telemedicine consultation in my telemedicine company. Initially, I started helping patients getting COVID testing through mail orders. I was focusing on reviewing available data from research publication and explore possible treatments, mostly with repurposed medication that has passed safety profile by the FDA. So I'm here today to provide clarity regarding the condition imposed by the Washington Medical Condition Commission and to demonstrate that the claims of unprofessional conduct and refusal or restriction of license authority in another jurisdiction are not supported by the facts. The agreed order issued by the Washington Medical Commission does not constitute a restriction, revocation, or suspension of my medical license in Washington. The order outlined a specific condition related to my telemedicine practice, such as requiring physician-patient relationship to be established through video consultation or in person, and agree not to prescribe ivermectin for non-FDA approved use. This condition, while specific, do not prevent me from practicing medicine in Washington State or any other state where I'm licensed. Moreover, the agreed order was a resolution of concerns and does not indicate any finding of dishonorable or unethical behavior that would trigger a violation of Mississippi Code 732529 AD. Compliance with agreed terms allow me to continue practicing without restriction in my specialty. I'm allowed to diagnose and treat patients in the state where I'm licensed with no restrictions, which does not meet the statutory threshold for licensing refusal or restriction in another jurisdiction. The allegation of professional conduct appears to center enforcing the Washington Medical Commission COVID misinformation notice on August 2021, which is currently being contested in federal court by the Silent Liberty Foundation, as the Washington Commission required to convert the notice into law in order to enforce an inviting complaint from the public for prescribing ivermectin and hydroxychloroquine off-label. The Washington Medical Commission case focused on prescribing ivermectin for non-FDA approved use and procedural deficiencies in telemedicine consultation, alleging non-establishing patient-provider relationship. It's important to emphasize that during the early months of the pandemic, many practitioners were prescribing non-FDA approved medications and supplements for COVID, including vitamin C, zinc, melatonin, antibiotics, hydroxychloroquine, which was EUA, steroids for non-hypoxic patients, which in current research increased the mortality rate in high-risk patients. My prescribing practice were guided by peer-reviewed research and the best available medical knowledge during that time and tailored to individual patient needs. All patients provided informed consent, understanding the off-label nature of the medication, and were evaluated through two real-time communication, such as a video conference call. My documentation reflects clear medical justification for these decisions. The Washington Medical Commission disciplinary action relied on incomplete records caused by my telemedicine vendor, Medici, abruptly and illegally terminating services and refusing to provide full patient files, which are clear HIPAA violation by the vendor. Despite my effort, including subpoena from the Washington Medical Commission, and my attorney demands filing complaints to HSS, Medici failed to cooperate. This lack of reliable evidence creates a significant risk of erroneous conclusion and undermines the fairness of the Washington Medical Commission findings. Substantial evidence required completeness and reliability, neither of which was present in my case. When Medici terminated service, I immediately notified patients of the disruption. I implemented alternative communication methods and ensured continuity of care. I cooperated fully with the Washington Medical Commission, submitting all available records to me and working to resolve the vendor non-compliance. This action reflects my commitment to patient care and my good faith effort to comply with regulatory standards despite circumstances beyond my control. It's critical to note that the Washington Medical Commission investigation was incomplete. They did not review full and complete medical records, ignore or dismiss the telemedicine vendor misconduct as evidence, did not investigate further the telemedicine vendor HIPAA violation, did not consider mitigating factor when I tend to recover the records, immediately alert the patients about the disruption, and moreover, did not identify any harm to my patients. The care I provide met telemedicine standard as mentioned in the letter of cooperation to the Washington Medical Commission. I complete real-time two-way communication video call with patients. I provide informed consent for telemedicine serving off-label treatment, and there is no evidence that public safety was ever at risk. This allegation focuses on procedural issues based on speculation, not the quality of care or outcome for my patients. In addition, no state board have ever denied me a license application under the Washington Commission agreed order, or even several state boards have issued letters dismissing Washington Medical Commission action, and some others have invited me to convert my compact license to a full license with no further processing or requirements.
Right. Thank you for that. At this time, counsel.
I would call Dr. Antonatos as an adverse witness. Dr. Antonatos, where are you physically located right now?
I'm in Panama City, Panama.
Okay. What is your current practice address?
My practice address is still in Chicago, Illinois. It's 4813 North Milwaukee Avenue, Chicago, Illinois.
And that was also your practice address at the time the Washington State Medical Commission issued its disciplinary order. Is that correct?
That's correct.
Do you physically practice in the United States at this time, or is your practice limited to telemedicine?
My practice is limited to telemedicine since 2021 when I left my prior employer, Northwestern Hospital in Chicago, Illinois.
Dr. Antonatos, is it your position that the Washington decision is invalid?
This is not relevant to the case, so I was planning to challenge their decision as well.
Okay. I'm not sure that I understood your answer. So are you saying that the order is flawed or that it is just invalid and shouldn't be given any weight?
I object to this question of it requires legal analysis.
Your objection is overruled. Please answer the question.
So the commission agreed order is valid. I have been complying with all the requirements that the commission requested for me to comply. So it's valid in my opinion.
Okay. And so you did not appeal the issuance of that order like in the court system?
No, this agreed order was signed under duress as the Washington Medical Commission avoid including the critical evidence that the medical files were incomplete. They did not admit that. Also, I have the issue with a telemedicine vendor who hijacked all my medical records, and I was only able to provide what I had available, which was the patient intake and some communication through text messaging with the patients. But most of the file, I would say 90% of the file, the telemedicine company kept with them, and the Washington Commission did not complete their investigation.
All right, Dr. Antonatos, you raised or your lawyer raised those allegations about the evidence or what you perceive to be insufficiency of evidence. You and your lawyer raised that to the Washington State Medical Commission before the agreed order was entered, correct?
Correct.
And the Washington State Medical Commission rejected that, and you signed an agreed order with the commission.
Correct. Yeah, under duress, as the evidence was dismissed, and they did not consider any mitigating factor when I attempt to get to contact all the patients and provide alternative method of communication for continuity of care. This was a mitigating factor that was not considered. In that time, my legal counsel stated that there is no chance to win this case if they go to hearing, as the medical commission was threatening with severe disciplinary actions.
Since Dr. Antonatos did not appeal that order and is now attempting to make a collateral attack against that order, again, I would object to, I will not attempt to elucidate any more testimony or elicit any more testimony. And I would object to any testimony concerning the Medici matter.
I will sustain that objection.
Dr. Antonatos, if you would, please look at page 10, MSBML 10. Do you have that available?
Yes.
All right, I just want to go through some of the statements in this order. First of all, the first paragraph. The Washington Medical Commission, through Michael L. Farrell, Commission Staff Attorney, and Respondent, represented by counsel Jessica M. Krieger, stipulate and agree to the following. Dr. Antonatos, what does the word stipulate mean?
That's stipulate is that I admit. I believe so. However, I objected this question as a required legal analysis, legal expertise.
Overruled.
Again, stipulate and agree, Dr. Antonatos. Do you not understand that you were committing yourself to all of the words that are contained in this document?
Yeah, I have to admit under duress, all this document. So yeah, I admit under duress.
And you had an attorney at that time representing you before the commission?
Yes, I have a attorney that probably I was bad advised by the attorney.
Okay. If you would look down that page to paragraph 1.5, just tell me if I read this correctly. The parties agree to resolve this matter by means of this stipulated findings of fact, conclusions of law, and agreed order. I read that correctly?
Yes.
1.6, respondent waives the opportunity for a hearing on the statement of charges if the commission accepts this agreed order. Did I read that correctly?
Yes.
And then there's another couple of paragraphs about what would happen if the order was not accepted by the commission, but it was in fact accepted and signed by the commission.
Yes.
And for anyone who wants, any of the board members who just want to review it, the official signature is on page 25, signed by the panel chair for the Washington Medical Commission and Michael Farrell. And that page is dated August 24th of 33. I believe it's the 24th. Do you agree, Dr. Antonatos, that's the date and those are the signatures of the commission and the commission attorney?
Yes, I agree.
Okay, look back at page 24. There's a signature line for Miguel R. Antonatos, MD, respondent, and the date is given of 8/10/2023. Is that your signature?
Yes, that's my signature.
Underneath that, there's a signature line for Jessica M. Krieger, and it gives a Washington State bar number, and there is a handwritten signature. Is that the signature of your lawyer?
I believe so.
Okay. And again, since you did not appeal the entry of this order, you understand that it became final by its terms on August 24th, 2023.
Yeah, I understand.
Right. All right, if you would look on page 11 at paragraph 2.3.
Yes.
Respondent prescribed ivermectin to at least 4 patients residing in the state of Washington through text to MD as detailed below. Each of these patients began their encounter with respondent by submitting a questionnaire via respondent's website. Respondent did not have a previously established physician-patient relationship with any of these 4 patients. In each case, respondent prescribed ivermectin based solely on a review of an online questionnaire. Respondent did not examine these patients or use real-time video or audio to consult or interact with these patients. Now, you agreed to that in this order, and I just asking you, is that not true, Dr. Antonatos?
That is not true. I have to
That's not-
agree under duress, but it doesn't mean that it's an admission of truth.
Okay. I guess this is a legal issue. He's alleging duress in the entry of this order, but on the other hand, he stated that he was not challenging the validity of the order. I believe those are contradictory legal positions.
Just a follow-up question regarding duress. Do you have any action against your attorney at this time who was representing you when you signed this order from Washington?
No, but I have been, the reason I have no proceed with legal action is all this year, last year, I have been dealing with 33 medical state boards to keep my license. And it has been very exhausting to hearing after hearing, and I have not have time. But now, this year, I believe Mississippi and there is a Tennessee hearing pending on March. After that, I'm gonna start legal proceedings, and I'm gonna submit a complaint on the 42 USC CS 1983 in a federal court against the Washington Medical Commission decision.
Okay, not your, but your attorney who advised you. At any time, did you talk to any other members of the legal profession regarding your claim of duress when signing this order?
Yeah, I spoke with another attorney. He suggested me that I should sue for malpractice.
Are they present today?
No, they're not here.
Okay, thank you. You may continue with questions, counsel.
All right. Well, Dr. Antonatos, let me approach this another way also. Respondent prescribed ivermectin to at least 4 patients residing in the state of Washington through Text 2MD as detailed below. Is that true?
I prescribe ivermectin. Yes, that's true.
Okay. Each of these patients began their encounter with the respondent by submitting a questionnaire via respondent's website. Is that true?
The encounter was not started that way. That's a patient intake form that I believe they misinterpret what is an intake form and what is a questionnaire. That was the intake form that I have from my patients. So the Washington Commission used the intake form as the whole reason for the disciplinary action. Given the facts that the evidence and then the documents that was not allowed here as exhibit show the evidence that my patient files and a complete record were hijacked by another company.
Dr. Antonatos, are you alleging that in fact you did have interactive audio, visual, real-time contact with these patients and that this paragraph is inaccurate?
I did have, the Washington Commission did not believe that based on the evidence they gathered, the incomplete medical records that they gathered. Based on that incomplete investigation, incomplete medical records, they based on this fact, which is not true.
Okay, you say it is not true. What part of it is not true?
It's not true that the consultation was done only by a clinical questionnaire. That's not true.
Okay.
There was interaction with the patient. There was a video communication. In different states, they have different laws in order to establish a patient relation through telemedicine. Some states are rigorous. Some other states are more flexible. Washington State, one of the states that require video calls for patient consultation and establishing a patient-provider relation. So the state that I do the telemedicine consultation where is required video call and two-way communication interaction, I complete with these requirements.
So you're telling this board that you signed the stipulated findings of fact, conclusions of law, and agreed order with the advice of counsel, but that it is not true?
It is not true.
And I want to ask you a question, Dr. Antonatos, or some questions about some documents you submitted in connection with your application. Apologize, I have to find the right page. The licensure file is quite extensive. Okay, I apologize to the board and to Dr. Antonatos. If you would look at page MSBML 27, which is a part of the licensure file that Dr. Antonatos previously asked to be admitted and that we did not object. If it has not been formally admitted, then I offer pages 27 through 127 into evidence as a part of Dr. Antonatos' licensure file.
Any objection?
No objection.
So admitted.
Okay, Dr. Antonatos, this appears to me to be a statement that a written statement that you sent in connection with your application, and it begins, "Dear members of the medical board." Is this a letter, a written communication, written statement that you made to our licensure division?
Yes.
Okay. All right, if you would, turn to page 29, look at the bottom.
Yes.
You mentioned a number of jurisdictions that have not taken disciplinary action against you I believe it was in your opening statement. Now, if you look at the bottom of page 29, it says summary of disciplinary actions. And the first one is Washington State initial disciplinary action. Correct?
Correct.
Okay. And you state beneath that, agreed order not to prescribe ivermectin, the requirement to conduct telemedicine video calls for new patients, continuing medical education CME requirement, imposed a fine, required a personal appearance before the board. Now, that is your description of the action taken by the Washington Medical Commission, is it not?
Yes, that's what I.
Okay. Then there's a statement, reciprocal disciplinary actions in other states. Michigan, reprimand letter and fine. Idaho, reprimand letter. West Virginia, reprimand letter. Colorado, reprimand letter. Tennessee, reprimand letter and fine. Maryland, reprimand letter. I'm sorry, Ms. Court Reporter. North Dakota, reprimand letter. Kansas, reprimand letter. West Virginia, additional reprimand letter. And then there's the statement, these actions reflect the widespread impact and response across multiple states to the initial disciplinary measures taken by the Washington Medical Commission. That is your statement, your description of the disciplinary actions that have been taken against you, correct?
Correct.
Do you wish to change anything in that statement?
No, this is what has been included as disciplinary action. Well, I just need to add this week I received a reprimand letter from Minnesota as well.
Okay.
That was not included as it happened this week on Monday.
All right. Well, thank you for sharing that information that we had not received yet. Thank you. Minnesota, correct?
Yes.
Okay. Out of curiosity, why did West Virginia issue you 2 reprimand letters?
I don't understand. I just received one.
Well, in your list, which we were just looking at, it listed West Virginia reprimand letter, and then at the end it says West Virginia additional reprimand letter.
Yeah, this is related to the Washington Commission case, nothing related to patient in West Virginia.
All right, let's talk about the way you practice telemedicine. Describe the text-to-med practice platform to me. How does a patient sign up for your service or become your patient?
So patients have to go to first, the website, and then from the website there is a different medical service that I offer to the patients. So when patients select a service, it shows another page showing what the service consists, the pricing, and there is a link for them to either download a telemedicine application, which is HIPAA compliant, or also there is a portal for the patient to sign in, and then we can complete telemedicine consultation this way. A patient usually requests the consultations. I determine based on their issue or the complaint if I able to help them out, or this require higher level of care, or could be seen by telemedicine. Then what I do is I schedule a consultation with the patient for a video call, conference call. Prior to that, I ask patient to fill several forms, including informed consent form for telemedicine, HIPAA compliance, all the regulatory mandated forms, including a patient ID as well for the identification. And then we start a telemedicine consultation through a video call, conference call.
Okay. And it is your sworn testimony today that you practice that way and used audio-visual communication with your patients at the time of the events described in the Washington agreed order and specified for the 4 patients listed in that order. Is that your testimony?
Yes, yes, I did, and I gathering patient affidavits as well.
Dr. Antonatos, if your application for a Mississippi license was approved, would you practice solely through telemedicine?
Yeah, this current time, focus on only telemedicine. Based on there is a huge need for healthcare accessibility in mostly rural, underserved areas. Also, telemedicine help with health inequities, as able to access a patient that not able to get healthcare in a prompt or easy way without having to travel miles. So yeah, this journey with telemedicine since 2018, I started, and patients have been very grateful to have me as a telemedicine physician when they're not able to locate a doctor in their area, or if they have to drive long distances. So I will continue helping these patients.
Do you have any plans to return to the state of Washington and ask that commission to change or lift its order?
Yeah, I have sent to the Washington Medical Commission, mostly the officer that is in charge of my case. I have sent letters to review the evidence again for the Medici vendor. and to review the emails that I send all the patients. As far as the disruption of the service that I send it November 5, I get the service disrupted. November 7, I send a mass email to all the patients. And so I issued all this again to the Washington Commission to consider this as a further evidence to reamend their agreed order or revoke, if possible.
Has the Washington Medical Commission acted on your request?
They have not yet.
Hey, doctor, if you would, turn to page 446. This is the Mississippi regulations governing telemedicine, which was previously introduced. And I just want to make sure that you understand a couple of these requirements. On page 447, the term real-time telemedicine is defined as real-time communication using interactive audio and visual equipment, such as a video conference with a specialist, also known as synchronous communication. Do you understand that definition?
Yes, I'm very familiar with synchronous video conference.
Look at paragraph H. Store and forward transfer technology is defined as technology which facilitates the gathering of data from the patient via secure email or messaging service, which is then used for formulation of a diagnosis and treatment plan, also known as asynchronous communication. Do you understand that term?
Yeah, I'm very familiar with this modality as well. As I complement both modalities in my practice, in order to establish patient-provider relationship, I get to know the patient first by a video conference call. Then patients, if they require any help additional or any questions, I offer a way to text so he can bypass mostly call centers, and there is no delay in getting the patient answers. So I use both modalities. That's probably the reason the text, and probably the Washington Commission misinterpret that text to MD means only texting the doctor. But no, I'm completely follow the regulations of each state medical board. If they have established a video call is necessary to establish a patient-provider relationship, that's what I do. If they don't have anything specific or they allow other modalities, I review on that and I do other modalities. Plus, I do my modality. My main modality is video calls, as this patient usually need to be examined at least visually. So my main modality is video call, and then I follow up patient with texting, or they can reach me out by texting. This is the main use of the text messaging for patient follow-up, for patient providing instructions after the consultation. So this is what I provide to the Washington Medical Commission, mostly patient text messaging from the application that was not hijacked, that I still have text messaging communication with patients after their consultation were completed. Some patients, before the consultation, when they download the app, they text me with a request. Then after that, we set up a time for a video call consultation. After the consultation is completed, I send patient instructions to the text messaging application. So they can have it with them and review it in case it's necessary.
Thank you, Dr. Antonatos. And while you were giving that answer, I just realized that I don't want to appear rude. We've got cameras in multiple locations around the room, but I'm having to look at you on a monitor here to the left. So from my perspective, I'm looking right at you. So I don't want you to think
no, it's
I'm
okay.
being rude. Okay. On the bottom of page 447, Rule 5.4, physician-patient relationship, I would just like to to go through these requirements that are the Mississippi requirements. In order to practice any form of telemedicine as defined in Rule 5.1, a valid physician-patient relationship must be established. The elements of this valid relationship are: A, verify that the person requesting the medical treatment is in fact who they claim to be. How do you verify the identity of your patients?
When patient requests a consultation, we send forms, including ID, a government ID. They need to submit either a driver license or passport card. And then I review that when the patient start the consultation. This is the same picture, it's the same date of birth. So that's why I review patient identification.
Okay, the next one, I believe you earlier testified about determining whether or not you could treat a patient via telemedicine. And requirement B is conducting an appropriate history and physical examination, thank you, of the patient that meets the applicable standard of care. So are you able to treat all patients via telemedicine?
No, no patients are appropriate for telemedicine. Many patients need to be seen in person, mostly when patients have any severe symptoms or symptoms that are not appropriate for telemedicine. Those patients need to be seen in person by a healthcare provider. So not all patients are candidates for telemedicine services, and that's something that I have been doing since the beginning. There is patient also with multiple complex medical issues that it will be better served by a multi-specialty care, multidisciplinary team, which they are not appropriate for telemedicine. The telemedicine patient that I focus mostly managing is patient which require non-urgent care, and I specified this in my term and agreement that this is not for urgencies. So it's patients either require sometimes a medication refill, like a cholesterol medicine, are traveling around the state, they forgot their medicine. Patient with stable conditions, like for example, patient with asthma, forgot the albuterol inhaler and is traveling out of state and need the albuterol, but it doesn't have any symptoms, no exacerbations. I also see patient for weight loss nowadays. I see patient for weight loss. I still see patient for COVID, but mostly patient with COVID long haul symptoms. This is what I'm seeing now. I don't use ivermectin anymore. I don't need to use ivermectin anymore. I don't need to use any non-FDA approved drug for COVID, as there is vaccine widely available. There is treatment, patient treatment. So those patients, acute COVID, I don't see any longer, only during the pandemic.
And I don't mean to interrupt you, doctor, but let me ask you a follow-up question. If you determine that a patient is not appropriate for telemedicine, do you have an existing relationship with physical providers located where the patient lives that you can refer that patient to?
No, I don't have a relationship physically with the providers in the patient location. However, I can refer them to Orient Care close to their location. I can just do a Google search and provide a few addresses in case patient is no candidate for telemedicine service.
Okay, so you do the Google search or you ask the patients to do it?
Usually, I try to help them out in case they mention that they don't know where to go. I try to help them out. If they know already, they mentioned they have Orient Care around their area, but they don't want to try out first telemedicine, I let them go there. But if patient is clueless about where to go, I try to help them out.
Okay, doctor, let me move on through the other requirements. Requirement C, establishing a diagnosis through the use of accepted medical practices, i.e. a patient history, mental status exam, physical exam, and appropriate diagnostic and laboratory testing. And so just yes or no, doctor, do you do that in your practice of telemedicine?
Yes.
Okay. If your patients need lab tests, How do you do that? How do you order that? Where do they have the
I-
labs done?
So I have an account with Quest Diagnostics and LabCorp, and I have an account with another company that provide laboratory services, ship the lab test to the patient home address, and then I provide the information of phlebotomies around the area. So patient can call the phlebotomist, the phlebotomist take the sample, mail it to the laboratory center, and I get the patient results straight to my platform. Quest Diagnostics and LabCorp, sometimes they fax me the results, sometimes they send it directly to me. So it varies depending of the laboratory center I select, and mostly depending on geographic location of patient, if they have a LabCorp, Quest Diagnostic, or if they don't have any of those, I mail the laboratory order to the patient, the lab kit, basically.
Okay. Requirement D, discussing with the patient the diagnosis, risk, and benefits of various treatment options to obtain informed consent. Yes or no? Do you do that with your telemedicine patients?
Yes.
Okay. E, ensuring the availability of appropriate follow-up care.
Yes.
You do that? How do you do it?
In my platform, I have a scheduling messages. When patient is seen in the platform, I send a follow-up message for the patient just to check on their symptoms. And I always have the application open for them. It's not when I done with their consultation, they don't have access to me. The application is always there. It's free to use. They can text me unlimited times during the day and the month. I don't charge for any of this. Only for the initial consultation and when patients require additional help on different health matters. But as far as follow-up care, I usually follow with this patient through an automatic system that send a message automatic to the patient to ensure what they're doing. And at the end of the consultation, I always let them know to text me if anything going on. If we need to get together again, we get together again. So I usually recommend this to the patient. Patient don't, I don't hear much from the patient back. It's probably because they're doing better. But I have been situations where patients are, for example, treating a sinus infection, and patient after the treatment course is still symptomatic. They let me know, and I refer them to in-person care, as this is not appropriate if non-resolved infections to continue treating through telemedicine. So yeah, I ensure I follow up with all the patients that I see through telemedicine.
Okay. Requirement F, and you've already told us something about the allegations against the medical records company. Requirement F requires maintaining a complete medical record available to patient and other treating healthcare providers. So do you now do that with your telemedicine patients?
Yeah, I always, I used to do it with the Medici too, but we have a disagreement and they decide to cut me off completely and take all the patient record. But right now I'm with different company with different platform, and I have the patient record, the complete patient record since I broke up with Medici since November 5, 2021.
All right. And there's one more key provision, Rule 5.5, that I have to go over with you, Dr. Antonatos. And I'm just going to read it to you and then at the end ask you to comment. Providers using telemedicine technologies to provide medical care to patients located in Mississippi must provide an appropriate examination prior to diagnosis and treatment of the patient. However, this exam need not be in person if the technology is sufficient to provide the same information to the physician as if the exam had been performed face-to-face. Store and forward transfer technology may be used to enhance, but never replace, real-time provider-patient interaction. Provider-patient interaction may be audio-visual or audio only where medically appropriate. So do you understand that requirement?
Yes, I understand.
Okay. Let me ask you this. If the statements of fact in the Washington order that you agreed to and signed, if they were in fact true, that you had not used audio-visual interaction with the patients, if that was true, that would also violate this Mississippi rule, wouldn't it?
Yeah, absolutely.
I beg your indulgence for one moment. That's all.
Any board members need to stand up? I don't want to take a break, but if you need to stand up, that's fine.
Sorry, I didn't mean to.
You're back. You may continue, counsel.
Yes, ma'am. Thank you. I'm just reviewing my notes to see if there's anything else that I'd like to ask Dr. Antonatos. I have nothing further at this time.
Thank you. At this time, Dr. Antonatos, we're going to open up the floor to the board for any questions they may have for you.
Dr. Roth.
Hey, Randy Roth, anyway, it doesn't matter. Pascagoula, Mississippi, real quick. Are there any archived platforms where your video and or audio interactions with your patients are archived and can be brought back up?
Yeah, unfortunately, I don't record patient videos without the consent. So the only record I have is video call logs with the timing that was stamped through the Medici platform. But unfortunately, I could not retrieve this evidence for the commission.
So the 4 patients that you prescribed ivermectin for, you had a video and or audio interaction with those 4 patients. Is that correct?
Yes, that's correct.
And can you reveal those or prove those?
Pardon me?
Can you prove or reveal audio evidence of doctor-patient interaction concerning those 4 patients?
Based on incomplete records, I cannot prove it from my medical records. However, patients can witness, and I have been trying to locate the patients. I have been over 3 years that I saw these patients. They have not returned to the practice. So I have been trying to get affidavits, trying to locate the patient to obtain affidavits so they can attest that the consultation were done by video call.
That's all I have. Thank you.
Okay, any additional questions?
So Dr. Antonatos, are you still practicing telemedicine in the US?
Yes, I'm still practicing telemedicine in the United States, and now I'm licensed in Panama, in the country, and I'm implementing telemedicine here as well.
So do you just do you do telemedicine in Panama as well?
Yes, I'm a licensed physician in Panama as well.
Do you see any patients face to face there?
A few. I don't have a office location in Panama City, but I've seen a few patients, mostly, I would say, has been a patient referred by other friends. We have been doing mostly through telemedicine, but nothing right now in person. Probably I have seen one of my employees that got sick, having some sinus infection, and I treated her here in Panama City. She comes to work with me every day.
What happened to your records with the Medici company?
So yeah, so the issue with them, back in November, there is a chronological record.
Actually, prior to that information, I sustained an objection regarding any questions regarding the issue with the Medici company and the medical records. So the questions are retained to the information and evidence, as well as the letters and information that were emitted. So he cannot answer that question.
Okay, thank you. No further questions. Thank you.
Dr. Antonatos, I'm Dr. Owens, and I guess my question is, you have the practice location in Chicago, but like how many offices or locations do you have for your practice?
So the practice is registered in different states. Illinois, because I used to live in Chicago, Illinois. So that's where I started the entity. And then I have moved to Florida. The entity have an entity in Florida, have one in Delaware, have another one in Texas, and have another one in Minnesota.
So you have a total of 5 U.S. locations, physical locations, for your company.
For the business, yeah, registered in the business through in the States.
And how is your time spent? Like, do you actually, I know when you do telemedicine, some of the flexibility is you can sometimes have the opportunity to do it anywhere. Do you split your time between those locations? Do you actually visit those physical locations often? Do you split time in between those locations? Or are you primarily somewhere else? Either.
Yeah, the locations are mostly to register the business. There are no medical facilities, so I don't often go to those locations, as there is no patients. I don't receive medications from those locations either. So there are no medical facilities. Those locations are just locations where I have my agent registering the business.
So and so what do you consider your home?
Right now, Panama City, Panama.
Okay. Thank you.
Any additional questions?
Prior to this issue with your license, do you know or do you have a record to reflect how many patients you engaged with on your through your business that were Mississippi patients, or did you have any at all?
Yeah, I believe I see a patient in Mississippi during the pandemic. Then since my record were hijacked, then I continue seeing patients from Mississippi with other companies, as I also a consultant for other telemedicine companies. So I have seen a patient with other telemedicine companies that are being located in Mississippi, not from my own company.
And do you collaborate with advanced practice providers, nurses, or PAs?
No, I don't have any collaboration agreement.
Any additional questions? Okay, counsel.
Dr. Antonatos, our executive director is Dr. Kenneth Cleveland, who's here in the room. If Dr. Cleveland was to request medical records from you for patients in Mississippi, would you provide those records?
Yeah, I will need to ask the other companies that I work to request those records. or Mississippi can subpoena those records to the telemedicine companies where I work as well. But I can try to facilitate those records. I'm not sure if they record the video call consultation as they may have a video call log, but yeah, if this is required, I can request to show the evidence.
Have you taken any additional steps to archive or back up your patient records, your medical records? So if in the future there was a problem, you would have a backup to go to?
Yes, I have definitely. I learned a lot, my lesson there. So yeah, I have a HIPAA compliant agreement with Google. So I have patient record files with them. I have mostly what have been done with the consultation, prescriptions. Video call log is difficult to transfer from one platform to Google spreadsheet because it may look that it was flown or someone manipulate the communication. So this is the challenging part. The video logs, if the platform decide to break again with me and being violate an amount of HIPAA laws, then I will be vulnerable again. But yeah, I definitely keeping all the records that I can take with me from the platform, that I can transfer from the platform to me in my own practice. So yeah, unfortunately, I have to depend on telemedicine platform and vendors to continue the practice. However, I'm developing a new application of my own to keep this with me. It's nothing that not finalizing that yet or anything. Is still I'm still working on the application.
Thank you.
Do you have any other witnesses?
I have no further witnesses. Complaint counsel rests.
Okay. At this time, Dr. Antonatos, do you have any witnesses to present?
No, I don't have any more witness.
Okay, then we will move to closing statements. But I do have a housekeeping matter prior to that. Madam Court Reporter has requested a copy of your opening statement, Doctor, so that we can have a complete and accurate record of these opening statement. So if you have that drafted, do you mind emailing that copy of your opening and closing, if you have that drafted, to the board for review?
Yeah, absolutely.
Perfect. Thank you so much. Counsel, you may proceed.
This is a first for me. We've got a doctor who on the stand here is directly contradicting the terms of an agreed order and stipulation of fact that he entered into with another medical board and which he signed when he was represented by counsel. And that order was entered approximately, if my math is correct, approximately 17 months ago. And this problem with the medical records was something that supposedly existed before this order was ever entered. And yet Dr. Antonatos has not. He says that he has sent Washington some additional information, but that order has not been changed. There's nothing of record that we can find. The Washington order and the version that is, I included it just for this purpose, the version that starts on page 450. Page 450 is actually the certification, and it says these records are considered certified by the Department of Health. So this copy of that stipulated findings of fact, conclusions of law, and agreed order, that is the official record of that order in the state of Washington. And there have been no further record changes. The two versions are diametrically opposed. The order of the Washington State Medical Commission is entitled to full faith and credit. The record reflects that it was issued after Dr. Antonatos was provided due process, access and advice of counsel, and he asserts duress. But as I understand his testimony, the duress was that the Washington Medical Commission said, we either have to reach an agreed order or we go to hearing on these charges. I do not believe that meets the legal definition of duress. I don't think that qualifies as duress sufficient to invalidate an order of a medical board. Now, if Dr. Antonatos, in fact, practices as he testified today with regards to telemedicine, obviously there could be issues that might arise with the particular patients, depending on their conditions, but the practice model he described would appear to comply with the Mississippi regulations. So I'm glad that my job here is done in providing you the information. The hard decision, it lies with you to decide how to handle this application. Do you deny it outright? Do you direct Dr. Antonatos to go back to the state of Washington to cure his problems there? But this matter now, that Washington order is there, it is official, and that is what was provided to this board, licensure division, and Dr. Cleveland. That is what Dr. Cleveland's decision was based on, and we have not been provided with any additional matters or communications with the state of Washington or the commission or anything to consider prior to this hearing. So I respectfully request that that the board deny the application.
You may proceed with closing statements, Doctor.
Yeah. So yeah, I just want to comment that the Washington Medical Commission case against me is still unresolved. I still haven't proceed with a legal action contesting their decision, which is planned to do very soon. I just gathering information and affidavit from my patients. I'm planning to file a federal court complaint under 43 USC 1983 based on due violation of due process. So the penalty imposed by the Washington Medical Commission, including the agreed order and prescribing ivermectin for non-FDA approved use, fines, personal appearance, and CME requirements were disproportionate given the procedural nature of the allegations and the absence of patient harm. Extending reciprocal discipline or license denial based on these flawed findings will unjustly compound the impact in my career and reputation and will be punitive in nature. Furthermore, the agreed order from Washington does not state that I engage in dishonorable or unethical conduct. It reflects a resolution to ensure alignment with state guidelines, no finding of malpractice or harm. There is no evidence to suggest that my actions were intended to deceive, defraud, or harm the public. On the contrary, my goal was always to provide patients with informed and ethical care in an unprecedented global pandemic and public health crisis. Mississippi Code 732529-8D requires evidence of conduct that is dishonorable, unethical, or likely to deceive, defraud, or harm the public. The Washington Medical Commission agreed order does not make such findings. Instead, it acknowledged that concerns were resolved through targeted practice modifications, demonstrating a collaborative effort rather than punitive action. Additionally, Mississippi Code 732583A refers to a professional conduct involving harm or fraud. My record has supported my documentation on patient outcomes show no instance of harm, fraud, or unethical actions. Therefore, these allegations are not substantiated by facts. In conclusion, the Washington Medical Commission agreed order does not restrict my ability to practice medicine or set forth conditions that I have to adhere responsibly. Furthermore, the allegation of professional conduct lack evidentiary support. There is no evidence of harm, fraud, or unethical intent. I respectfully ask the board to carefully review the facts, consider procedural deficiencies, mitigating factors, and evaluate my qualification independently, denying licensure and applying disciplinary action based on incomplete and reliable evidence would be unjust and disproportionate and punitive. Thank you for your time and consideration.
Thank you. This concludes the hearing in this matter. I will turn it back to Madam President.
Thank you, Ms. Morris. You have heard the testimony and the issues related to this matter. Is there a motion?
Second.
It's been moved and properly seconded that we close the meeting to consider whether to go into executive session. Any further discussion? Hearing none, all those in favor? Aye. Any opposed or abstention? The meeting is closed.
You said this is gonna be. Thank you, Paul. I don't really like it. I don't know why. I need one. I think one more. If so, I will not mention your name.
Dr. Antonatos?
Yes,
Okay, yes, I understand that you have a statement or request that you would like to make to the board prior to deliberating in this matter. Would you care to give that at this time?
yeah, I would like to withdraw my application for license.
Okay. Counsel, any?
No, thank you. Well, then I guess that concludes this matter as Dr. Antonatos has withdrawn his application.
Thank you. Thank you, Dr. Antonatos.
Thank you.
Since we are concluded, hearing officer, Madam President, I'll turn it over to you.
Want me to be the hearing officer? Everybody gets to be. Okay, guys, thanks to everybody for hanging into a long but important 2 days. Last item on the agenda is our next board meetings, the next board meeting. For some reason, I can never find that piece of paper. You don't show me this stuff, I can't see. Yeah, so, the dates that we have right now are March 19th, Wednesday, March 19th, and Thursday, March 20th. Everybody check your calendars and see if that works. I think that misses our spring break, doesn't it, Ken? I think so. Yeah, that's right, the 19th and the 20th. Which should be the week following spring break and St. Patrick's Day. Does that sound good for everyone? So that'll be the 19th and the 20th. Just a friendly reminder that the FSMB is going to be just over a month after that, April 24th through the 26th. So if you haven't already, let Francis know if you're planning to attend. I think Ken made that announcement on yesterday, but I'd just like to reiterate that if you do plan to attend. Anything further from anyone else? Ken, anything from your side?
No, ma'am.
All right. Lisa, thank you so much for all your help. Happy New Year, everybody, and we are adjourned. Please.